people who are under court orders to perform certain things as a review of what your progress is. So Bob Bell's going to call the names of people who have reviews. Come up when your name's called to the table to your right.
Jessica Bailey, Casey Barker, John Barker, Tyree Clutters, Betty Inyard, Kelly Green.
Okay, Jessica Bailey is 2519.
Yes, Your Honor.
All right, she's on teleconference. Okay, you still have community service to do. Do you have a payment you're making?
Yeah, I will pay it today that I'm making, and then by the time I come back and see you, I will for sure have my community service done, because I have facilitated it where my job works around what I need to do in my applications.
Okay, I'm not sure you've done any since April, so I want a commitment. Give me a day when you're going to do community service.
I will be, actually tomorrow, I'll give you a day tomorrow.
Okay, that works. You got that?
All right.
I'll give you a new review hearing date. Okay, I'm going to set it for the 14th of September.
Okay.
September 14th is your next hearing, 9 o'clock.
All right, thanks, Your Honor.
You're welcome. Casey Barker is here. 11/3/49, 12/29/15, 21/6/14. For reviewed your files this morning. You're just paying on fines. Do you have a payment today?
I was hoping to. I do not, Your Honor, but I will be in the morning to do some community service.
Okay. Mr. Cooper's got that down. And I'm going to set you for September the 11th, 9 o'clock. That's a Friday.
Thank you, Your Honor.
You're welcome. John Barker. Case number is 23-194 and 23-115. So you turn
He's just turned some community service in.
Does it look acceptable?
Yes, Your Honor.
Okay.
He done Lawrence County Animal.
All right. Do you have payment on your funds?
Yes, sir, $50.
Okay. Okay, go see the clerk to make your payment. Does it matter what day of the week you come back?
No, sir.
Okay, I'm going to set it for September 21st. That's a Monday. 9 o'clock, September 21st. Go see the clerk to make your payment.
Thank you, sir.
You're welcome. Tyree Clutters, 252985 is here.
Your Honor, if I may, he turned community service in this morning also. 13 hours. I will have to call and verify it though.
Okay. All right, you did make a payment yesterday, it looks like, so,
Yes, Your Honor.
okay. Yours is a newer case, and we'll go a little further out for you. Is it Mondays or Fridays, does it matter?
Preferably Fridays.
Okay. I'm actually going to go into October on yours then. So October 2nd will be your next hearing. That's the first Friday in October. You get it finished by then, you don't have to show up. October 2nd, 9 o'clock.
Thank you, Your Honor.
You're welcome. Benny Inyard, 25-13-21 is not here. Still has a small balance and 1 day of community service. So it'll be a warrant for failure here. Kelly Green this year, $25,489. Fines paid, you just have to finish your community service. I'm showing you got 3 days left. You've done 2 since the last.
Yes, sir.
Okay, get that done and you'll be finished. Mondays or Fridays? Doesn't matter.
Friday preferably.
September 25th.
That's our jury trial day.
Oh, okay, sorry. We're gonna try to keep that light, so. We'll do it October 2nd. October 2nd, 9 o'clock, get it finished, you don't have to come in.
October 2nd.
Yes, ma'am. 9 o'clock.
Heather Humphrey, Kenny Ingalls, Alan Kennard, Ashley Mays, Bryce McGinnis, Austin Pritchard.
Heather Humphreys, 24/1981. Okay, got a report from Presbyteria. It says you're compliant.
Yes.
Okay, you got the fines to pay too. Do you have a payment on your fines?
Yes, Your Honor. I have $20 today.
Okay, see the clerk, if you're paying that. I'm gonna set yours is an older case, so September the 18th,
Okay.
will be your next hearing, 9 o'clock.
Thank you, Your Honor.
You're welcome.
Have a good day.
Good. Good to see the clerk.
All right.
Kenny Ingalls is here. He's at RRS. Got a report from them. Okay, it's a good report, and it says you've got your first year clean from drugs and alcohol, so congratulations.
Yep.
Okay, good report. Can you pay anything on your fines?
Yeah, I got $20.
Okay. Good job.
Thank you.
Good to see the clerk. And I'm gonna put you on the 18th of September as your next hearing. 9 o'clock. Alan Kennard, 25/686, 25/2731. Okay, got a certificate of completion from the VA. Okay, let's make copies of that, and we'll just keep copies in the file. Oops, sorry. Okay, Kent, we've got fines and community service. Can you pay anything on your fines today?
Yes, I can pay $50.
Okay. And what about your community service? You gotta get some of that done. You gotta-
Yeah, I'm gonna start Monday,
Okay.
Your Honor.
All right, see the clerk. I'll set you for September 21, that's a Monday. September 21 at 9 o'clock will be your next hearing. Let's get some of your community service done, go see the clerk to make your payment. Okay, good job on your counseling.
Thank you, Your Honor.
Ashley Mays, 23,517. Just making payments, and some of this is restitution. Okay. Most of it's restitution, so you got a payment today?
Yes.
How much?
20.
Okay. I'm going to set you for the 11th of September. 9 o'clock, to see the clerk to make the payment. Bryce McGinnis, 25,526, 25,2109. Is that RRS? All right, looks like you missed a session, but you did come in and make it up, and you took a screen after that, and it was negative, so that's good. You still have a couple days community service to do.
Yes, Your Honor.
Okay. When can you get that done? Give me a date when you're gonna come out and do one of the days.
I could do Monday and Tuesday if that works.
Okay, Tuesday would be best, so that's next week. It's gonna be the 11th, so you'll be here on the 11th.
Thank you, Your Honor.
Your next hearing, I'll set your next hearing for October 2nd. 9 o'clock, that's a Friday.
Thank you, Your Honor.
You're welcome. Austin Pritchard, 18, 1233 and 1234. Just making payments, so you have a payment today.
Yeah, 60.
$60.
Yep.
Set you for September the 11th as your next hearing, 9 o'clock. See you first, make your payment.
Thank you.
You're welcome.
William Richardson, Joseph Sherman, Jason Stapleton, Mark Wells, John Jones II.
William Richardson, 21,846, 21,566. He's a Southern Hub.
He was. That's his discharge summary, Your Honor. I think he came to us June 23rd, left 4 days later, relapse, came back 7/1. We notified the court. We gave him an opportunity, and he left 7/27 ASA.
What do you say, Mr. Richardson?
He's not here. He's
I thought he
ASA.
was here, okay. All right, so there'll be a warrant issued for failure to appear. Thank you for the report.
You're welcome.
Joseph Sherman, 25,387.
Your Honor, if I may, I had noted that Mr. Sherman was ordered to do community service, and he has just handed me 10 hours of community service. Looks like he done it at the Lawrence County Animal Shelter.
Okay, thank you. He's at, well, you were at UFR. Are you still at UFR?
No, sir. They dropped my charges and took my ankle monitor off, and they told me I didn't have to stay anymore.
Were you going there from another court then?
Sorry, come again?
Were you going there from another court?
Yes, from common police.
Okay. You still have community service to do here.
Yes, I do it every Sunday on at the dog pound.
Okay. Is he finished now?
He has turned in 10 hours. I don't know what
Okay,
he
he still
said.
has some left then. Okay, I'm going to go October 2nd on your next hearing, 9 o'clock.
Thank you, sir.
Get it finished, you don't have to come in.
Yes, sir.
Jason Stapleton. Jason Stapleton is not here. He's got a bunch of files. 15/11/67, 24/2033, 25/5/25, 25/17/96. He has things left to do, so there'll be a warrant for not appearing today. Mark Wells is here. It's case number 2014, 2073, 17/12/73, and you're paying on funds. You have a payment.
20.
Okay, I'm going to set you for September the 8th. Now, that's a Tuesday, because the 7th is Labor Day. That's on a Monday. So, come in on Tuesday, September the 8th, for your next hearing at 9 o'clock. See the clerk to make your payment.
All right, thank you.
You're welcome. John Jones, the second, 26/3/44. A report from TPC.
Arraignment, first time appearing.
Okay, very good. I like one particular sentence in here, it stands out to me. In addition to his personal progress, John has become a positive role model and influence among his peers by encouraging others, following program expectations, actively participating. Sounds like you're transitioning to a lower level of care, so, okay, good job.
Thank you.
Can you pay anything on your funds today?
$100.
All right. See the clerk, make your payment. I'll set you for October 2nd. First Friday in October, October 2nd, 9 o'clock. Okay,
Thank you.
Good job.
Thank you.
Ready for arraignment, Your Honor.
Okay, that finishes the reviews. We're going to start the new cases now, which are called arraignments, or if an old case, if you had a warrant outstanding and came in to get that recalled, you're going to get called with these hearings. Dale's going to call the names of people that have cases. When your name's called, come up to the table to your right, stand there, we'll go over the charge with you. The prosecutor decides the charges. I don't decide the charges. I don't have any input into that. So when I'm reading them, usually that's the first time I've seen the charge. It may not be true. It could be false. But it is what's alleged against you, and you need to understand what's alleged against you by the state. You have a right to remain silent. You don't have to say anything. If you do make statements, what you're saying is on the record. There's actually, we're video and everything now. So if you get up and admit something about your case, there's going to be a video of you saying what you're saying. And the state can use that against you later. If you want to talk about your case and get some advice on it, it's best to do that with a lawyer in private, because that's what's called privileged in the law. It can't be used against you. But what you say in open court is not privileged. It can be used against you. You have a right to have an attorney. You have a right to have one appointed if you're facing a jailable offense and you qualify financially. You have a right to have bail. You have a right to make the state prove the charge they file against you beyond a reasonable doubt. That's the highest proof standard in the law. If you decide to enter guilty or no contest, you're giving up that proof standard. You're saying, I admit or at least I'm not denying that I'm guilty. And you shouldn't do that if you don't understand what's happening, if you're confused, if you don't know what to do. Not guilty is the plea you need to enter then. Call the first case.
State of Ohio versus Krista Petrus, case number TRC 261372.
And ma'am, are you Krista Danielle Petrus?
Yes, sir.
Ms. Petrus, it's alleged on August 4th, 3:30 a.m. in Perry Township. States alleged you were driving a motor vehicle while you were under the influence of alcohol. They're saying you took a breath test and tested 19 on the breath test. And that this would be your first, if you got convicted, would be your first conviction. So the penalties go up the more convictions you have. So on a first offense, the maximum penalty is 6 months in jail, a $1,075 fine, and a 3-year license suspension. With your test score, the minimum penalty is 3 days in jail and 3 days in a treatment program, $565 fine, and a 1-year license suspension. The test score of 19, there's 2 numbers that are important on the breath test scores. The per se level, which is 8. So if you test 8 or higher, there can be a presumption that you were impaired because you tested 8 or higher. The state has to show compliance with the rules for giving the test to get that presumption. The other number that's important is 17. If you test 17 or higher, it's considered a high test, and that's where the mandatory jail comes in, even on a first offense. So the state's alleging that you have a high test score because it's above 1.7. So the mandatory jail as a minimum applies on that. Do you understand all that I'm explaining to you?
Yes, sir.
You have one other charge, driving outside your lane. That's a minor misdemeanor. There's no jail time on that. Maximum penalty is $150 fine. So those are the 2 charges you face. Do you understand them? Do you understand the rights you have as a defendant?
Yes, sir.
How do you wish to plead to these charges?
Not guilty.
You want a lawyer appointed to represent you?
Yeah, I'm going to try to apply for a attorney.
Are you working?
Yes.
What do you do?
I'm an STNA at a nursing home.
Are you paid by the hour?
Yeah.
How much per hour?
22 on weekends and 20 throughout the week.
Okay, I have to determine your gross annual income to see if you comply. It depends on your family size too. How many people are you supporting? Do you have children?
I have one son, but he'll be back in the household this Thursday, but he's not right now.
How old is he?
21.
Okay, well, you can't claim him, he's an adult. You're not going to be qualified then for a court-appointed lawyer if you're making that much per hour, because you're going to be above the level where I can appoint a counsel for
Okay.
you. So I'll give you some time to hire a lawyer. I mean,
Okay.
a not guilty plea for you. Let's look at what the schedules look like. Probably not going to set any pre-trials until September in any event. So if I set it for the 4th of September, you think you could have a lawyer by then? That's almost a month.
Yes.
Okay, September the 4th is going to be your next hearing date. I'm going to write that down. There's a form there in that little basket for your next hearing date. Put on there, September 4th. It'll be at 10 a.m. It'll be a pretrial. Putting down, you will hire a lawyer. I'm going to let you sign a signature bond. What that means is $1,000 signature bond. You sign a piece of paper that says, "I promise I'm coming to court when ordered, or I'll pay a penalty of $1,000, plus you get a warrant for not showing up." So just come to court, you won't have to deposit anything in court. And she will need to get fingerprinted, and bail will bring you a form to take to the jail. The jail's, you live in Kentucky, right?
Yes, sir.
Okay, so do you know where the jail is in Lawrence County? It's across, do you know where the courthouse is in Lawrence County?
Yes, sir.
Right
Park
downtown
Avenue.
Ironton?
Yep.
Okay. The jail's right across the street from courthouse. You gotta go there, take this form, ring the buzzer, tell them you're there to get fingerprinted, and they'll let you leave. You're not gonna have to stay, but you do have to get fingerprinted. Do it before your next hearing.
Okay.
Any questions?
No, sir.
You are under an automatic license suspension, which will apply in Kentucky too. Okay. September 4th, 10 o'clock, is your next hearing.
Thank you.
State of Ohio versus Caleb Ham, case number CRA 25809, CRB 24765.
And, sir, you're Caleb Ham?
Yes, Your Honor. I had a review on the 3rd, and I didn't realize it and missed it.
Okay. And it looks like, on one case, you just have to pay court costs, the other, you've got some community service and fines to pay. You did do 1 day of community service?
Yes, and I'll be here tomorrow as well.
Okay. Cooper's got that down. No warrant had been issued yet. It won't be issued since you came in today.
And for the payment, I get paid on Tuesday night, so I was going to come in Wednesday morning. And how much do I owe? What's left?
$25 on one case and $455 on the other, so $480 looks like.
Okay, I'll be able to pay like $200 Wednesday.
Okay. I'll set your next hearing, Mondays or Fridays, does it matter?
Prefer Fridays.
October 2nd is your next hearing. That's the first Friday in October, 9 o'clock.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Terry Hager, case number CRB 26127, TRC 26383.
All right, Mr. Hager is been coming for sentencing hearings. You're supposed to go to the VA and you've never done it. So what I've got set up, I'm going to order you not to depart the courthouse and have Mr. Major get in touch with either Ms. Rayburn or the other fellow whose name I don't recall about getting him set up with the VA. We want to make that connection today, or you're going to have to go back into custody of the jail. So you are going to go to treatment with the VA. They've got good resources, so let's have it recalled after we try to make that connection with the Veterans Administration.
Sir?
Yes, sir?
I'm in treatment with Valley Health, which I have been since,
I'm going to order that you go to the VA for substance use. So go meet with Mr. Major,
okay.
and they'll get in touch with the VA. They can probably take care of your other medical issues too. So go meet and let's see what comes of it. We'll come back after you talk with them.
Thanks, sir.
State of Ohio versus Austin Bates, case number TRC 23209, A and B.
And this was set for pretrial back in April 28th of 23. So this is 3 years ago. It looks like the allegations you failed to appear for that pretrial.
Yes, sir. I got shortly incarcerated after that. I've been incarcerated ever since.
Okay. When did you get released?
4 days ago.
From?
Kentucky, Southeast State Correctional Complex in Southeast Kentucky.
Okay.
I just wanted to try to get out and take care of this.
Where are you going to be living now?
In Kentucky. I'm staying with my grandmother currently, trying to take care of her.
prior address in Green Oak or some other?
Is that a 6430 is what you have written down?
1627 State Route 1?
No, this is a new address.
Give me your new address.
Okay, 6430, KY 503, Argolite, Kentucky.
503?
Yes, sir. Argolite, it's Argillite.
Okay. Your attorney, you have an attorney, Mr. Smith, he's not here today.
Okay,
So what I'm going to do, I'll cancel the warrant, there had been a warrant outstanding for you. I'll cancel it since you came in today,
thank you, sir.
and I'll just give you another hearing date. And
Okay.
do we have Mr. Smith's schedule?
Your Honor,
Hang on.
Okay.
I wrote down the schedules for everybody, Your Honor.
Okay.
These are all the bad days.
Okay, these are the bad dates. Are there any dates you're not available, sir?
Not currently, I'm looking for employment, but haven't, got a couple interviews coming up, but I don't have anything secure yet, so any day should be fine.
Okay, I'm going to set you for August 24th as a pretrial at 10 o'clock. Do we have a card for Mr. Smith? Okay, we'll give you Mr. Smith's card. It's been a while since you've had contact with him. You should get in touch with him.
Okay.
Be back here August 24th at 10 o'clock.
Okay, thank you, sir.
You're welcome.
State of Ohio versus Aaron Howe, case number TRC 261369, A and B.
This is a new agreement. And sir, you, Aaron Michael Howe.
Yes, sir.
Mr. Howe, it's alleged on August the 3rd at 4:16 a.m. in Perry Township, you were driving a vehicle while you were under the influence of alcohol, drugs, or some combination of those things. State's alleging that you submitted to a urine test, so those go to the lab for testing, and it takes several weeks to get results. I don't have any results today on what they're going to say was shown by the test. It is alleged that this would be your first offense if you're found guilty. On first, the maximum is 6 months in jail, $1,075 fine, 3-year license suspension. You can't get more than that if you're convicted. There is a minimum, which means I can't go below a certain level if you're found guilty, and that is 3 days in a treatment program, $565 fine, and a 1-year license suspension. That's the minimum now. That's fairly new since March. They upped the minimums. Do you understand that charge?
Yes, sir.
You have also been charged with driving out of your lane. That's a minor misdemeanor. Maximum penalty is $150 fine. Those are the 2 charges. Do you understand the charges?
Yes, sir.
Do you understand the rights of defendants that I explained at the beginning of court?
Yes, sir.
How do you wish to plead to these charges?
Not guilty.
Do you want a lawyer appointed to represent you?
Yes.
Do you have a job?
Yes.
What do you do?
I'm a car detailer at Dutch Miller Ford in Ashland.
Are you paid by the hour?
Yes.
How much per hour?
12,
Okay. How many hours a week are you working?
40. Can't work over more than that.
Okay, you're eligible for court-appointed counsel, and I'll appoint Mr. Stratton to represent you.
Morning, sir. Morning. Could you write your phone number down there?
Not guilty plea is entered, so we're probably looking at 9 weeks out before there's any chance of getting the test results back.
No. Okay.
Mondays or Fridays?
Any date except those dates, Your Honor? I have listed there.
About the 9th of October.
Sounds good.
October 9th? Yes, that's a good date for you, according to the list I have. October 9th, pretrial at 10 o'clock. Mr. Howe can sign a no-R bond. He will have to go to the jail to get fingerprinted. The bail for bringing that form to take to the jail with him to get fingerprinted. $1,000 OR bond.
All right, we're good. I'll just wait for him outside. Okay.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Ronald Gumbert, case number CRB 26479, A and B.
This is Ronald Gumbert. There's two charges. 479A case number alleges that on August the 2nd, Fayette Township, you did purposely try to deprive Walmart of property without their consent. It's a first-degree misdemeanor theft offense, maximum penalty is 6 months in jail, $1,000 fine. And then the next charge is just a different day. Same charge alleges a separate incident on August 3rd, same possible penalty. Do you understand the charges?
Yes, sir.
Do you understand your rights?
Yes, sir.
How do you plead to these charges?
Not guilty.
And you've posted a bond.
Yes, sir.
You want a court-appointed lawyer?
Yes, sir.
You have a job now?
No.
No income?
No.
I'll appoint Roger Smith to represent you. Set your next hearing for August 24th for a pretrial, 10 o'clock. His bond is continued. All right, guilty plea is entered. Any questions, Mr. Gumbert?
No, sir.
Be back on the 24th before 10 a.m.
All right. Thank you.
You're welcome.
State of Ohio versus Kermit Shane Kirk, case number CRB 26481.
He's got one more charge. Let me get him.
Are you Kermit Kirk?
Yes, sir.
Okay. And, sir, you're Kermit Shane Kirk?
Yes, sir.
Mr. Kirk, the state's filed two charges against you. The first is obstructing official business, in which it's alleged on August the 5th, without the right to do so, you purposely prevented, obstructed, or delayed a public official in performance of their official duties or impeded them in the performance of their lawful duties. That's a second-degree misdemeanor, carries a maximum penalty 90 days in jail, $750 fine. The second charge is resisting arrest. It alleges August 5th, Fayette Township, you resisted the lawful arrest of yourself. That's a second-degree misdemeanor, maximum penalty 90 days in jail, $750 fine. You understand these two charges?
Kind of in a way, yes, sir.
Okay, you don't have to agree with them, but you need to understand them.
Yes, sir.
You understand the rights you have as a defendant?
Not really, but
I mean, I'll go over them again. I explained it. It's, if you watch any crime shows on TV, you've heard it 100 times because it comes from a famous case, Miranda versus Arizona. Your Miranda rights, you have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney. You have a right to have one appointed. You have a right to bail. You have a right to make the state prove the charge beyond a reasonable doubt. You understand those
yes,
things?
yes, sir.
How do you wish to plead to these charges?
I reckon I'll plead guilty. I don't know.
Well, this is, I mean, these are two serious charges. If you're not sure, I would plead not guilty. Have you talked to a lawyer?
No, sir. I have not. I have not got the money to.
Well, you're entitled, if you meet the financial guidelines, to get a court-appointed lawyer. So do you want to be considered for a court-appointed lawyer?
Yes.
Are you working?
No.
You have no income?
Only what I draw a month. SSI, I reckon.
Okay.
I don't know, sir.
Well, you're qualified for court appointed counsel. I'll appoint Mr. Stratton to represent you.
Excuse me, sir.
What's your number again?
Enter a not guilty plea.
Excuse me, sir.
I'm entering a not guilty plea for you.
Okay, thank you, sir.
He's got a bond up,
He
Mr.
does,
Stratton, so
okay.
I'm going to continue his bond that he posted. And let's,
I want to make sure on this phone that we're okay. I want to pass my sister. I mean, I'm just trying to be honest with you, sir.
All right. Yeah, we're being recorded, so that.
let's do the 21st. You're available the 21st.
Yes, sir.
Of August, Your Honor?
Yes.
Yeah, okay.
August 21st will be the next hearing, 10 o'clock.
August 21st, sir. I'll just
Thank you.
make sure that number's correct.
For 1 second, I'll walk this back there and let you know.
Okay.
Okay. Over 32, 32. Yes, sir, that's right, sir.
Okay, gotcha. Yep.
Thank you. Okay.
Good to go.
I'm free to go for it.
State of Ohio versus Gary Jackson, case number CRB 26484 A. Gary Jackson.
So are you Gary J. Jackson?
Yes, sir.
Yes, she's.
I think you've just been served with charges. There's 2 domestic violence complaints. 484A alleges that on August the 4th, Union Township, you knowingly caused or tried to cause physical harm to Jessica Jackson, and that Jessica is a member of your family or lives in your household. That's a domestic violence charge, maximum penalty is 6 months in jail, $1,000 fine. The second charge is the same date, time, that alleges a different victim, it alleges Charlie Henson, also a member of your family or household. So it's same thing, domestic violence, maximum penalty, 6 months in jail, $1,000 fine. You understand the charge?
Yes, sir.
How do you plead?
Not guilty.
You want a lawyer appointed?
Yeah, I'd like to have one.
Are you working?
I work for myself. I do odd jobs.
Okay. Do you file an income tax return?
No. I just started doing this, so
Okay. Do you have any money saved?
very little.
All right. I'll appoint Roger Smith. You have not posted a bond, so I'm going to let you sign a signature bond since you showed up on your own. What that means is you're just going to promise to come to court, or you'll pay a penalty of $1,000 for not showing up, and you get a warrant for not showing up.
Okay.
What's the state's position on protection orders and going forward on this?
What's your name? Okay, so Jessica Jackson's here, and she does not want a protection order, but Carly Hansen is not here, and we're going to request a protection order for her.
Okay, it's Carly. I think I misread that. Okay, there'll be, is that a problem? Who is Carly? Is she a relative or?
She's my daughter.
Okay, does she live in the same household?
She moved her stuff out yesterday. She's living with her father now.
Okay, so it's not a problem for him to stay away from her?
No.
Okay, at least while this case is pending, we'll go over, you stay away from Carl.
Okay.
So that way there's just no allegations of something else happening. And then we need to set another date for you to come back. August 24th will be the next hearing. It's a Monday, August 24th. Pre-trial at 10 o'clock. Any questions, Mr. Mr. Jackson?
No, sir.
August 24th, somebody give you Mr. Smith's card? Okay,
yes.
yeah. August 24th, 10 o'clock, your next hearing.
Thank you.
You're welcome.
State of Ohio versus James Cook, case number TRC 26756, A, B, and C.
That case we're going to call last for today.
Okay, this is the one set for jury trial next week.
Yes,
Okay, so
we're
we'll
going
call it.
to, yeah, call it at the end, so we're going to deal with that last.
State of Ohio versus Dina Cornwell, case number TRC 251846, A and B, CRB 25473, CRB 25444.
Dean Cornwell is set for a pretrial today. It's supposed to be at RRS. Never came. And haven't shown today, so the bench warrant for fails.
State of Ohio versus Paul David Crum, case number TRC 26903, A, B, and C. Paul David Crum.
I'm not sure where Paul is.
This is set for pretrial today.
We didn't have any results on this case yet, so it's just going to be reset. There's a rain back on the 5th of June, so.
What's the state's position on it?
Well, we still think, we don't have the results back, but we think we should be here anyway, so we've asked for a bench warrant.
Okay, he's got 7 days to get in before a warrant will issue.
Yes, Your Honor.
State of Ohio versus Grady Diamond, case number CRB 26182.
Set for pretrial.
That's TCC. We need gentleman from TCC.
Oh, Ron Carbon, Mr. Carbon.
Yeah, that's.
Saw him. We need Mr. Carbon in the courtroom, please.
One quit, and the new one came.
There he is.
Grady Diamond.
Good morning.
Can we come back in a few minutes?
I'm sorry.
Can you recall this?
Yes, we'll recall.
Okay, all right, I'll see.
State of Ohio versus Mariah Hannah, case number TRC 26755.
Your Honor, this one of two that we're going to deal with at the end of the docket. Sorry about that, so.
Okay, we'll recall it later.
Yes. Sorry, Greg.
State of Ohio versus Corey Craig Easton, case number CRB 26371, A and B, CRA 25810, CRB 25811. Corey Craig Easton.
She admitted reads.
Oh, that LCR.
Was at one time she went to art, but I thought she was going from there to admitted reads.
That's what I had.
I recommended Reed's could deal with it, with her, so she didn't go to trial. So that, maybe my notes are wrong.
I did have a report from admitted reads. The last report I have is from admitted reads, July 18th. I think she requested to go to LCR. We said, didn't we say, let's hold off and see?
Yeah,
see what happens with her.
yes.
She had been at Washington Recovery before, so let's try to reach out to Minute Breeze and see if she's even still there. Guess we're piling up. This will be a recall. We're piling up cases to recall.
Not, well, starting off good, aren't we?
It's going to get dark too.
Yeah.
State of Ohio versus Sherry Holland, case number CRB 26350, CRB 18857.
Mr. Stratt's case, pretrial.
Yes, Your Honor, she's at OVP.
It looks like we're about to get a report. Yes.
Sure, I can read the copy.
I can't either.
Kind of read it.
She's doing well, Your Honor. I think right now her plan, when she completes, is to follow up with outpatient with OVP in Huntington.
Okay. That's going to be toward the end of this month.
Yes.
It says on the 24th, Your Honor, so.
Okay. So maybe come back a little after that, see how things are going.
Yes.
In September, let's see, it looks like for you, on one date is out, that's the 8th. So
Which is that Tuesday? That's on it.
about the 4th, September 4th.
Yeah, that'll work.
Next hearing will be September 4th. She should be out doing outpatient at OVP.
Yes.
Thank you.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Kyle Maynard, case number CRB 26243, CRB 24478.
Mayor's Shawnee, Councilman. Okay, it's a very good report. Good job.
Thank you.
How do you feel about things?
Doing good.
Okay,
And your restitution.
all right.
That's good.
Well, let's continue there. Come back approximately a month. Maybe a little beyond that. How about the 18th of September, I think? Yeah, that's a good date for Mr. Stratton. September the 18th will be the next hearing, 10 o'clock.
Thank you, Your Honor.
Thanks, sir.
You're welcome.
We don't dismiss that case, or have they already done? All right.
State of Ohio versus Brock Mosder, case number CRB 26229.
Mr. Stratton's case, pretrial.
Your Honor, we don't have a letter from Pat today. We had one back on June 26th.
Right.
He will get a letter next time.
Yeah, I'll get
correct?
a letter. I've been working nights, so I've been tied up, so.
Is that what the state wants to do?
We're okay with that. We just maybe wanted the hearing to be a little sooner than we would otherwise ask for.
Yes,
That's right. Just make sure we get that to you.
Yeah, I'm tied up working nights, so we'll get this.
It's not bad.
28th of August,
Yes, Your Honor.
August 28th.
August 28th.
Next hearing.
I'll write on here.
3 weeks. Okay.
Thank you. Good.
All right, Mended Reeds is going to bring them before Easton. So they're on their way.
Okay.
Scott ordered that.
State of Ohio versus James Robinson II, case number PRC 261075.
Mr. Stratton's case, preliminary hearing and pretrial.
Are you in treatment already?
I doubt that we have results yet.
No, we don't have results yet on this one.
About 6 weeks, so we're a little early on that.
Yes.
What's our time frame?
The 90 days, if there hasn't been a time waiver, would run on September 28th.
We do have a felony pending also.
And we also have a felony pending, so that expands it.
Okay. So let's see. If we came back,
Yeah.
in early September, then we should be okay. About the 14th of September,
September 14th is fine, Your Honor.
should have the results by then. September 14th, preliminary hearing and pretrial.
You're good.
State of Ohio versus Anthony Wills, case number CRB 26408 and 407.
Stratton's case pretrial.
My feeling would be it was deserving of a little extra community service and a little extra suspended jail, if you wanted to do that today. Okay, that's fine.
Your Honor, we'll reset this for another pretrial.
Do you have a preference as to the time frame?
Within the next couple of weeks, Your Honor, except for those dates listed.
August 21st?
Yes.
10 o'clock, August 21st.
Thank you. Thank you.
State of Ohio versus Angel Brewer, case number CRB 26358.
Okay, this is Mr. Steyer's case. He is sick today and unable to be at work.
I'm sending out for Luke today.
So we just need to continue this. The state's going forward with it. What's the state's position on Amy Brewer, 26358?
Well, I'll tell you, we haven't at this point been able to have any kind of discussion with Mr. Steyer yet about the circumstances. The last hearing on July 13th, it was reported that Ms. Brewer was ill and couldn't be here, so we continued it to today. So I really think that under the circumstances, we just need to wait till Mr. Steiner can be here.
Okay.
That's fine, Your Honor.
I can bring you proof of my doctor's record if you need it.
That's okay. He hasn't asked for it, so. There was no warrant, so that's fine.
Sorry, I signed off.
Here, I'll write it down. Oh, there it is.
September 14th. September 14th.
I'll be here, thank you.
And I will, we'll, once we're done with this, tell Mr. Smith and Mr. Snyder the dates.
All right, thank you.
State of Ohio versus David Christian, case number CRA 26429, A, B, and C, CRC 261231, A and B.
I believe Mr. Christian is at RRS. Correct?
Yes.
Yeah.
It's Mr. Steyer's case, pre-trial preliminary hearing. Mr. Steyer is unable to be here today due to illness. He did a report that he's compliant.
Yes.
Okay, good job.
Thanks, sir.
Your Honor, I don't know whether Mr. Stratton is in a position to maybe help Mr. Christian along today, but there was some discussion about the fact that we've got 3 possession charges and he might have prescriptions for some or all those things, and I didn't know if he had anything with him today that might verify that. But we do want to have that at some point if he can provide it.
He does not have that with him today, Your Honor. So we'll just set this for Mr. Steyer to deal with that issue.
All right, you can obtain those from your pharmacy, sir. Okay, so Mr. Steyer, we'll be looking at, we'll set it for the 11th of September. Pre-trial preliminary hearing.
Thanks, sir.
I will make a note of that for Mr. Steyer.
State of Ohio versus Christina Nicely, case number CRB 26299. Also Mr. Steyer.
I think this case is a pretty complicated case, Your Honor. I heard a little bit about, talked a little bit about the prosecutor in the back. I'm just not sure where the prosecutor is on this.
Autumn?
What you want to do.
Well, we're going to seek conviction, so.
Okay, well, it's an M4, but due to Mr. Steyer being unable to be here, it'll be considered, of course, a request from the defense for continuance.
Well, we understand that, Your Honor. 21st of August. Okay.
August 21st will be the next hearing.
August 21st.
10 o'clock.
State of Ohio versus Javier Valdez, case number TRC 261238 and D. Understanding Mr. Valdez and his attorney, Mr. Bluffman, are both on video. Sure.
Okay, this is case number 261230. Good morning. Benjamin Lockman has entered appearance for the defendant, Mr. Valdez.
Correct, would you like a case status update, Your Honor?
Yes, I was just looking through the file to see what's been prepared so far. So this appears to be a first offense refusal as the main charge.
Correct.
Okay.
So, Your Honor, we've had some conversations with Mr. Heald prior to appearing before you here today. Reviewed the discovery discussed with my client. We would anticipate going and filing a motion to suppress based on reasonable suspicion running a probable cause. And then Mr. Heald and I agreed to discuss this matter further as well in terms of seeking a resolution.
Okay, so when can you have your motion filed?
Either later today or by Monday, it will be done shortly.
Okay, so then usually what we would do then is pre-trial the motion. If it's not resolved at the pre-trial, then we would.
Correct, yeah, so that's what Mr. Gill and I discussed, and I would anticipate doing.
All right, so let's try to get a pre-trial date. The 24th of August.
What time is this your?
10 a.m.
For now?
We could do it at 10 a.m. or if you wanted, we could do it at noon.
So I would be able to go and do it at noon if possible, because I had something scheduled earlier that morning, but I'm just a little bit behind to get there, but I can be there by noon. If that's okay with Mr. Gill, I don't know what his schedule is.
Well, when I spoke with Mr. Luffman yesterday evening, I suggested that a discussion about the motion and a resolution would be better if he was here.
Okay.
So whatever works for him in the court is fine with me.
He says he can be here at noon on the 24th. Is that?
That's fine.
I just want to make sure that we're okay with your schedule.
Okay, so we're going to set a pretrial on motion for the 24th, and it'll be at noon that day.
Perfect.
Okay.
Thank you very much, Your Honor, and I hope you have a wonderful weekend. Phil, take care. I'll talk to you soon, okay?
Thank you.
Thank you.
State of Ohio versus Sean Qualls, case number TRD 26817 A and B. I believe he is on Zoom.
Good morning, Your Honor.
Good morning. Okay, so it was my understanding, Mr. Qualls, that you wanted to hire a lawyer, is that correct?
Yes, Your Honor.
Have you done so?
I had got a hold of McCown Fisher, and he does not handle my type of cases. What his secretary told me, so they referred me over to Roger Smith, and he's out until August 12th for a family emergency.
Okay. Now, Mr. Smith practices in this court, and I have his schedule. So, at your request, then I'll continue it to September the 4th. Will be your next.
September 4th?
Yes, sir. September 4th, first Friday, and September 10 o'clock.
At 10 o'clock. Thank you, Your Honor.
You're welcome.
State of Ohio versus James Franklin, case number CRA 26465. Your Honor, he has been picked up by Kentucky.
Okay. Mr. Franklin had an extradition to Kentucky. He waived that, and I ordered them to pick him up by today, which they have. So the case here is dismissed.
State of Ohio recalls Brady Diamond, case number CRB 26182.
Okay, this is recalled to get a report from the counseling center.
apologize for the confusion, Your Honor. She is compliant with all treatment expectations currently.
Okay, thank you for that. How do you want to proceed, Mr. Stratton, Mr. Hewitt?
We want her to continue to be successful.
Yes, Your Honor, I think she just changed counselors at TCC, so.
Okay. The 18th of September?
Yes.
September 18 will be the next hearing, 10 o'clock. Continue with the council meeting.
Thank you, Your Honor.
Thank you.
State of Ohio versus Cody Mead, case number TRC 253047, A, B, C, and D, TRD 251553, TRD 251873, A and D, TRD 222101, this is the rental phase up there.
All right, Mr. Mead, it looks like you were supposed to be here July 31st, is that right?
Yes, sir.
And you didn't make it?
No, sir.
Do you have an explanation for that?
Our vehicle got down at the time, and I couldn't get the help to get here.
Okay. All right, well, unfortunately, Mr. Steyer is not here today because he's ill, so I'm going to have to continue your case again. Warrant will not issue. She came in today. I'm going to set it for September the 14th.
Thank you, sir.
Be a pre-trial on all your cases September 14th.
Thank you.
You're welcome. 10 o'clock, September 14th.
State of Ohio versus Marty Ray Tolliver, case number CRA 26425, CRA 25757.
Mr. Stratton's case, preliminary hearing and both preliminary hearings. Is that so? Got a report?
So, he's been looking to take us to the grand jury.
Okay. It's a good report. Sounds like there's progress made. Still things keeping work on.
Yeah.
Do you want to press on this, Mr. Hill?
Yeah, if you want.
Yes.
Yeah, probably.
Is this your case or is this? Yeah.
Turkey's kind of
Your Honor, at this time, we'll waive our preliminary hearing. Of course, I believe he signed his own bond on it, so I maintain.
He did sign an OR bond, so.
As that bond remain.
Yes, it will remain in effect. He has a GPS monitor, I believe, so at this point, we'll keep that in place. Yes, sir. May reconsider that later.
This is the waiver. It's just waiver rights. It doesn't lead to anything. It's just waiving the preliminary hearing. Just sign right there.
Does he continue his treatment?
Yes, continue at Bethesda. He has a case that he's already been convicted on here that is coming back for review hearings, and that this 26-425 is going to be nolly or waived to the grand jury, actually waived to the grand jury. So what you just signed, sir, is you have a right to have what's called a preliminary hearing. It's a probable cause hearing. It's not a prob. Just is there enough evidence for the state to take it to the grand jury, and you waive that. You understand?
Yes.
So I'll accept your waiver. That keeps your bond in place. The best thing you can do, I don't think anybody's going to disagree with this, is stay in treatment, do good in treatment, get good reports in treatment. Your case, this case is going to go on down to your injury, but that's the kind of thing they're going to look at. And if you come in with good reports, you'll get better treatment than you would if they had to, like if you took off and they had to drag you in by the scruff of the neck. You'll get different treatment then. So.
Yeah, I don't plan on leaving. I never plan on leaving it.
Stay where you are, do good, get good treatments, and that's going to help on your case that is going down to the grand jury.
I think you're going to set the rest for a review.
Yes, we'll come back for a review hearing in approximately a month or so. So let's see what we got. The 14th of September will be his review hearing.
September 14th, it's review, and that's at 9.
And then I'll look at whether the GPS monitor could be removed at that point.
Yes,
The more convinced I am that you're going to stay, then the more likely I am I'll take the monitor off. Okay?
I understand.
Thank you.
Thank you.
State of Ohio versus James Morris, case number CRA 26139. Mr. Morris is on Zoom.
He is on Zoom, Your Honor, and I also sent you his report by text.
Okay, yes, I did see that. He's at St. Joseph Recovery Center.
I should have said that to you too. Mr. Morrison.
That's in West, is it Steuben? Can't remember that. Where is that? It's in West Virginia.
Somersville.
Somersville. Okay.
Yeah, sort of cut it off down there.
So, state's position on it?
I understand it's a good report. So under the circumstances, we're okay for him to continue. Is he on the Zoom?
Yeah, he's right there.
We're okay with him to continue there.
Okay.
We had spoken about him appearing by Zoom before, Your Honor.
Yes, I remember that. September 14th?
Yes, that'll work.
September 14th, 10 o'clock will be Mr. Morse's next hearing. As long as he's compliant with treatment, he can continue to appear by teleconference.
All right, thank you, Your Honor.
You're welcome.
You're good to go, Mr. Morris. September 14th.
State of Ohio versus Mark Allen Simbala, case number CRA 26388.
I've got Mr. Stratton down, is he signing on that?
Oh, yeah.
Yes.
Just pay attention to my area. Focus. Yeah,
That's a good report.
Yes, sir.
Continue, monitor,
Yes.
September 14th.
That'll work.
Next hearing, September 14th.
14th, way out there. It'll be a minute before we get out there.
Thank you.
You're welcome.
State of Ohio versus Christopher McAllister, case number CRA 2720, CRB 2721, CRD 2019-7. Christopher McAllister.
So on 7/6, he had completed inpatient, post-go outpatient.
Especially the outpatient ODP.
He's not showing up for his appointments or anything, so she is requesting a higher level of care. He's kind of just doing, his last appointment was over telehealth, and the in-person ones, he's no call, no showed. So we're afraid he's using again.
All right, so he hadn't shown up today, so he'll have a warrant in 7 days if he doesn't appear, and then we'll consider requiring him to go out to some sort of inpatient then after that.
Okay. Thank you, Your Honor.
Did he do anything? Outpatient?
We've done like a couple of telehealth appointments, but in-person ones, he's not showing up. He hasn't shown up for the last 3.
Yeah, that's not trouble.
State of Ohio versus Charles Smith IV, case number CRA 26121, CRA 26155.
Your Honor, I believe Mr. Smith, we're going to dismiss this to QRT today.
Okay, I had that down as a question, QRT question mark.
Nathan's here.
You good with that?
Yeah.
Yeah, I'm good. I know you got it.
Charles Smith.
Yes, he's in county. Yeah, I went there Tuesday.
Okay, is it still appropriate to dismiss to the PRT?
Yes.
Yes, Your Honor, he's been compliant, he's doing well.
Okay. And that's both cases, there was 26-121, 26-155.
Yeah, they're both possession cases, Your Honor.
All right, those will be knowledge to the QRT.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Randall S. Jenkins, case number CRA 46422 A and B, PRC 261063. Mr. Stiers, case, Your Honor.
All right, Mr. Steyer is ill, not able to be here today. Mr. Stratton is standing up for him. Mr. Jenkins is at RRS. Say 2 consecutive negative screens. That's good.
Okay.
Very good report. Good job.
Your Honor, if we could, I believe I gave it to you, but I believe Mr. Steyer is going to be here on Monday. Is that correct?
Well, that's not one of the days that he marked off, so I would assume. Let's see what
Okay.
that looks like.
The state's wanting to take this to the grand jury. I think
Oh.
Mr. Steyer needs to speak to him about that.
Okay, so we can put it on the docket for this coming Monday, August 10th.
Okay.
August 10th will be the next hearing.
State of Ohio versus Caleb McDonald, case number CR 2669 A and B. Also Mr. Steyer's case.
Also Mr. Steyer's case, preliminary hearing.
Okay, I believe Kayla's at OBP, is that correct?
Yes, outpatient, yes.
Outpatient, yes.
Yes, she has been with OVP.
Yeah, so I received a verbal report from her counselor this morning. She said that Kayla did pass her drug screen and she is now back in compliance. So
Okay.
she's no longer failing for fentanyl,
All right.
which is what we wanted.
We'll come back in maybe a month.
Yes. Mr. Steyer's case.
Yes. 14th, September 14th. Preliminary hearing, September 14th.
Thank you, Your Honor.
Thank you.
You're welcome.
State of Ohio versus Raymond W. Meredith, case number CRB 25167.
Your Honor, I spoke with Mr. Ashford this morning. He is the special prosecutor on this.
Yes.
I have my text message thread with him if you would like to review it, but he will not be appearing. He asked if we could just take care of it.
Costs have been paid.
And so it's a dismissal, Your Honor. So if the court will allow to see those text messages, I can show them to you. But
I take your word for it as officer reports, the case will be dismissed.
okay, all right, dismissed.
Oh, hold on.
Hold on.
What was the there was a payment of 156. What was that?
Total 281, and I have to look at the
Okay. So apparently it was more than the usual cost. The sheriff fee.
Public defender fee. That needs to be taken on, that was twice. With the bench warrant. October 31st.
Oh, yeah, bench warrant fee at one point.
Up to pay the bench warrant and the other fees. Criminal court costs were put on, paid for those that have been paid.
Okay, that's not due credit.
Yeah, 125 is the, we could take 100 off that because it looks like the fee was accidentally put on twice, but the rest will just repeat services.
All right, so I'll reduce it by 100, so what's that balance then? $25, right?
Well, the 25 is where he can be taken off because he paid that twice. He wouldn't take
Okay.
it to be off also.
Let's look. Okay, yeah, he had a bench warrant in there. He was gone for several months. A warrant he got issued. So he still needs to take care of that.
Yeah,
I'll reduce it by $25 because he got double charged on the sign council fee.
So how much does he owe?
100.
100?
That's the bench warrant.
Okay. Just speaking with them, I think there's some confusion on these costs. Maybe you can explain to the court what you were just trying to explain to me?
Yes, sir. They charged my mom fines and court costs for this case, fines and court costs for the one that you transferred to the grand jury. And if you go back in our records, the only thing that I owed, maybe the bail bonds might be true, but I don't think so. The only thing I owed was 3 days community service, and I completed that. But after that, they charged my mom all this money, and she got receipts.
Okay, well, have her come in.
I will, today.
Okay, well, I'm going to just reset it for another date then. It's not going to be dismissed if it's not paid today.
What do you mean? I'll pay the $100.
Okay.
But I want the receipts to be looked at, if that's okay.
Well, you can bring them in and have the clerk go over. If there's been an overcharge, then we can deal with that. But you got to bring the proof in, so.
Okay.
He's going to pay the 100 today. Once it's paid, the case will be dismissed.
Okay, all right. Go pay that, I'll dismiss it.
State of Ohio versus Matthew Hoff, case number TRC 26136A and D. Mr. Price, case set for sentencing. I believe Mr. Hoff is on Zoom.
Yes, Your Honor, and I've got something you said about this case.
TPC. Maybe they sent
He
him.
was at TPC at one point.
I think maybe they sent him on
Okay.
to this facility.
So, you want to continue to monitor his treatment?
Yes, just schedule with Mr. Stein.
Let's do the 21st of September. So, Mr. Hoffman, your next hearing will be September 21st, and you can appear by teleconference as long as you are in compliance with your treatment.
Okay. So it's the 21st of September?
Yes, sir, 10 a.m.
Okay. Thank you.
You're welcome.
State of Ohio versus Daniel Barker, case number CRB 25262. Set for sentencing, Your Honor.
Your Honor.
Mr. Barker is Mr. Stratton's case set for sentencing.
Yes, Your Honor, we had talked about this on the 27th. He was attending the Williamsburg OVP. So Mr. Net
He has a bond up.
Could we recall this, Your Honor? Until I-
Yes, we'll recall it.
State of Ohio versus Clinton Haas, case number CRV 26225, CRA 26106, also set for sentencing.
Is that RRF?
Yes.
Stop away from that, please. Okay, it looks like a good report. Screens are good.
Yes, Your Honor.
This is Mr. Stratton's cases, so.
Do we either continue?
Continue,
Yes.
September 18th.
September 18th. September 18th? Oh. How much longer do you want to be here? No, yeah, okay.
State of Ohio versus Douglas Grant Hager, case number PRC 26362, A and B.
He's at Bethesda. So he's got pending OEI, whatever, and he's already pled guilty to that. I guess we're just letting him do treatment
Yes, Your Honor. It's all right. This is set for
for
sentencing.
sentencing.
Yeah.
He's still testing positive for THC.
Yeah, we're still waiting on the send-off results for that.
Okay.
But he has been coming to services. So,
September 21st?
Yes.
For sentencing.
State of Ohio versus Joseph A. Graham, case number 2375, and CRV 2375.
Joseph Graham, set for sentencing. He has a bond. I believe that's correct. Check. does have a bond up. He's got a cash bond up now. 25, he posted a cash bond of $2,500 on July 1st.
Just gonna look at that.
Okay. I'll order it forfeited. He hasn't appeared today, and it looks like he's not compliant with the treatment. And issue a warrant. For failure to appear.
State of Ohio versus Shannon Brunson, case number CRB 26468.
Okay, you were going to bring me a prescription today?
Yes, sir.
I didn't bring my, I had 2 weeks of these in a pill case at home. I was unaware that I should have brought them.
Said she has 2 weeks of field case at home.
What did she test for? Yeah. It's not in the front. Jacob got it in his file.
He does.
Oh, okay, that's fine.
You want?
Why don't you take this to him?
Is this our copy to keep, or do you want us to make a copy for the file?
Oh, no, you can have, you can keep it, yeah.
All right, is there anything else you want to show me before I'm going to go ahead and send you?
No, sir.
Okay, I'll impose a $100 fine. Order you to pay the court costs, 10 days in jail suspended, 30 hours community service, order you to stay out of Lowe's. Is this Lowe's or Walmart?
Walmart.
Walmart. Where you stay out of Walmart. Well, the complaint says Lowe's.
I know, I don't know why.
You have any
Yeah.
information on that, Mr.?
Well, it says female health and beauty items, so I'm assuming it was Walmart. So we moved to amend that in the complaint.
Okay.
It was
So I'll make it, order to stay out of Walmart. Review hearing will be February the 5th of next year at 9 a.m. Get it finished before then, you don't have to be here. You'll have probation for 2 years or until you're finished with everything. Meet with Mr. Major in probation. It's to the left as you go out of the courtroom.
Okay.
The windows to your left. Meet with him, and then you're free to go after that. Do you have any questions of me?
No, sir.
So, Mr. Major is his name. So
Major.
go to probation.
Okay.
Say, I need to sign my paperwork and get copies, and then you're free to go.
Thank you.
You're welcome.
Your Honor, we have a call from the Lawrence County Jail inmates who are back in court.
Okay, we've got inmates here in person, a bunch of them. It's a very busy week, so we're going to start on those now.
State of Ohio versus Ethan Anderson, case number CRA 24706.
For Anderson is Mr. Snyder's case.
Looks like he missed the hearing on,
We call something else that's here and recall the jail in just a moment.
okay. You got some things here. Paul?
State of Ohio versus Corey Easton, case number CRA 26371A and B.
I just checked that.
She left.
What, I'm sorry.
I was told she was on the way, then I'm told that she left and agrees. So there'll be a warrant for failure to appear in leaving treatment. For Corey Easton, that's case number 26371, 2581.
Ms. Dement was also going to send you a message, Your Honor, on Mr. Barker.
Okay. I'll be looking for it.
State of Ohio recalls Terry Hager, case number TRC 26383.
We probably need Mr. Major to come in the courtroom. Mr. Major in the courtroom.
Yes, Your Honor. So I've made contact with the VA. They advised me that it was impossible for them to get him in today. Even if they were in the office, nobody's in the office today.
Okay.
That it'd be Monday before they could get anything done with him. I had TCC try to screen him to try to get him in with the counseling center just until the VA can do it. But he doesn't, with the answers he's given them, he doesn't qualify for their services.
Okay. All right, Mr. Hager, I'm going to order you to appear at the VA at Spring Valley on Monday by noon and engage them in services, and then be back here for your next hearing on the 24th of August. And if you're
Back here on the 24th.
Yeah, if you're inpatient, they'll transport you.
Okay.
August 24th is your next hearing.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
Yes.
State of Ohio recalls Daniel Barker, case number CRB 25262.
Okay, I did get the message that he is compliant with treatment, but he's not here today, so you want to continue?
Yes, Your Honor. I do not have a phone number for Mr. Barker.
Maybe OVP does, but they said they were able to get in touch with him. They don't know why he didn't make it to court, but he's doing his treatment in Wheelersburg, you know, the Scioto County people. They're hard to count on him, so. So when do you want to come back?
Your Honor, whenever the court would like, and then I will ask Ms. Dement for a number.
Let's see. August is getting to be terrible. How about September 4th?
That'll work.
September 4th, the next hearing for Mr. Burke, sentencing.
State of Ohio versus Ethan Anderson, back in holding, case number CRA 24706.
This is actually Mr. Starr's case. Mr. Stratton's standing in for him since he's here today. Looks like Mr. Anderson has been in jail for a few days. He was at Focus at one point. Inpatient, left treatment. And I decided maybe he just needed a few days in jail because he took a test on the 3rd and was positive for amphetamine, buprenorphine, fentanyl, methamphetamine, and THC. So, what do you say? You want to go back to treatment, or what do you want to do?
Yes, sir.
Focus, want to take him, or
Not with an ankle monitor, sir.
not now?
He has to have an ankle monitor or we will not accept him back.
You would take him with an ankle monitor?
Yes, after he got to our services, we can't deny medical care, and he got to the hospital and left from the hospital within 4 hours of getting to our office.
Okay. Are you really going to go do the treatment, or are you going to go either cause problems? Because another time, I don't know if it was this incident, but like he just laid down and would refuse to get up. Yeah, I read about it. So, I mean, you can do that at the jail. I mean, if you want to just lay down and refuse to get up, I'm sure they can find a spot on the floor at the jail where you can do that. I wouldn't think, that would be my goal, is like, I want to stay out of the jail. Yeah, that's a good idea? You agree with me on that? Try to stay out of jail and do whatever you need to do to stay out of jail. And, okay, I'll order you back to Focus with an ankle monitor, and that's probably, it might happen today, it may not happen today. So let's put him on the docket for Monday in case it doesn't happen. So I can't guarantee you that they'll get the monitor because I don't control, the adult probation puts the monitors, and sometimes they don't happen on Friday for some reason. So we'll put you back on the docket for this coming Monday, which I believe is the 10th, yeah, August 10th. If you're already at Focus, good. If not, I'm sure we can make it happen Monday.
It's possible that it could be today, then?
It is possible. There is a chance. I'm saying there's a chance. You're welcome. Yeah, it'll be a 2,000 no work on. So take advantage of this and go get clean and have a good life. Okay?
State of Ohio versus Chester Burton Jr. Case number CRA 25798, CRB 25799.
This is Mr. Stiers' case. Okay. He had left treatment and her law got revoked.
So, Your Honor, apparently with that treatment, you left treatment, but you came straight here to get an ankle monitor on, and then they put him in jail.
Okay.
And I know Southern Hope has a bed available for him to go back to treatment. I don't think he needs an ankle monitor, Your Honor. It seems like he showed,
What do you say, Mr. Quan?
We'll accept it.
And you don't need an ankle monitor? Okay, and you'll say?
I apologize. LCR just wasn't with me, you know what I mean? Just sometimes it's like it worked for me, and I didn't want to sit there and be my head against the wall. I appreciate the opportunity to go there.
The state still willing to do that? I mean, there's a there's a possession charge in here. It's an old one, but he's got possession of fentanyl, still pending.
Well, Your Honor, forgive me, because part of the conversation just then, I was talking about another case.
Okay. He had left LCR. He came back here, he had an ankle monitor on, and he's been in jail for a little bit. Now he's going to go to Southern Hope, and they're willing to take him. He still has a felony pending.
Your Honor, if I may, Southern Hope brought him here.
Okay, so, he went there and reported. Is that
I
right?
had, can I be sure?
Yeah.
When I left LCR, I already had my bed at Southern Hope, and I had my girlfriend pick me up and then brought me straight here to Southern Hope met me.
Okay.
That's what that was.
All right, so I'll word him released to Southern Hope now. For inpatient. And come back.
Is he wearing an ankle monitor now?
No, it's off, ankle monitor's off, and I'm not gonna hook one back on it now. Let's come back on the 21st, August 21st. He had the hearing for the 14th, I'm canceling that, or moving it to the 21st. Okay, we'll see you in a couple weeks. Thanks. 2000.
State of Ohio versus Andrew R. Curry, case number CRB 26355, CRB 25506, TRD 252873.
And you are Andrew Curry. You got a new charge. So you've been served.
That's fine. I have not. That's what
We got. This got a staple.
Oh, yeah. What I'm saying is file discovery, so we've got a trail. It's a sentencing, so
Okay, so, Mr. Curry, this is a charge from back in April. Well, it's April 5th of 2026 in Union Township. You operated a motor vehicle to willfully elude or flee a police officer after you were given a visible or audible signal to bring your vehicle to a stop. That's a felony 4, maximum penalty is 18 months in jail, $5,000 fine. So, do you understand the charge?
Yes, I do.
And you've got other old cases. Mr. Stratton was your attorney on 25506 case that is still pending and had a warrant for failure to appear. Well, I think he had a review hearing on that one. Yes, he had a review hearing on May 26th. 26th was an aggravated menacing conviction. So I guess that one had been resolved. Then there's 252873. That was a traffic charge that was still pending, driving without a license. So I'll point you on everything, Mr. Stratton. The new charge is the biggie, it's fleeing and eluding, failure to comply. State's position on bond.
state would request a $10,000 cash surety bond.
Okay, I'll set bond at 10,000, cash for surety on the new charges. Appoint Mr. Stratton. When did you come into the jail, Mr. Curry?
I came from West Virginia, extradited up from West Virginia, extradited back in July 4th. I went to the regional jail, West Regional, and they extradited me back over.
When did you come to Lawrence County?
On the
I believe
third,
August the 3rd.
August 3rd.
Yeah, I did on the third day in West Virginia jail.
Well, we need to have the preliminary on Monday then, or?
Yes, Your Honor, let's just get this on Monday.
I'll set the preliminary for August the 10th. Pre-trials on the other traffic case and a review hearing on 25506. So that 10,000 cash or surety bond will cover all the cases. Everything you say is on the record.
Right now, I'm homeless right now. Me and my fiance, I'm walking with my wife, and I got some money to go cash. Mom was at 5,000 on that card before, and from that 10, I can go that. But I'm trying to. Right now, I'm talking to a landlord to rent a place, get off the street. Now, I can use that whole all my money to get out of bond, but I don't want to use that. I need a place to live. You know what I mean? And I've been already did the 30 days in West Virginia jail already. I mean, I know I do finance. I've been working finance through Chesapeake Municipal before. I know finance here. I was starting my community service. I just need a chance to get my life right. I need to. I already did the time in West Virginia jail, sir. I mean, I did over 30 days. I mean, I'm on that higher. I wasn't 5,000.
You failed to appear. You've got several cases where you failed to appear. And I read the affidavit. It's pretty aggravated situation. You're running through red lights at 60 miles an hour. It says in Huntington, downtown on 3rd Avenue, putting people's lives at risk. So I'm going to keep the bond at 10,000. That's all. I've heard enough. I'll let you speak.
All right, thank you,
State of Ohio versus Ashley Thomas, case number CRA 23745, CRB 23746.
All right, Ashley Donna was Mr. Steyer's case. He's sick, can't be here today. You were at one point under the test, left treatment. You came back in July, like you left treatment again. So I'm going to change your bond from, you have OR bond before. I'll set your bond now at 10,000 cash or surety. And put you on the docket for Monday, August 10th. Next hearing is Monday, August 10th. 10,000 cash or surety.
State of Ohio versus Arthur Thomas Haas, case number CRB 26483.
Sir, are you Arthur Thomas Haas? You're being served with the complaint. It's alleged Walmart theft, and it's a case alleges 26483 is the case number. It alleges on August the 5th, in Fayette Township, you tried to deprive Walmart of property. It's a first degree misdemeanor. Affidavit, maybe this one was this the one that should have been Lowe's? Mr. Hill?
I'm sorry, Your Honor.
He's saying he's not the Walmart. Was there a mix-up? Because one of the others that was Walmart had Lowe's on it. Because this one's talking about a pressure washer. I don't know, maybe this would have been Lowe's.
Well, I believe it was Walmart. Yeah, Walmart.
Was Walmart? Okay. They're sticking by it. They're saying Walmart, that you tried to steal a pressure washer from Walmart. They charge you with a first degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. You understand the charge? You have a right to remain silent. You don't have to say anything. If you do make statements, they're on the record. You have a right to bond, to have an attorney, to have one appointed if you can't afford one, and make the state prove this charge beyond a reasonable doubt. Do you understand those things? How do you plead? You want a lawyer? Do you have a job? You don't have any income? Okay, I'll appoint Mr. Steyer. You living still in Ironton? On Lincoln Street? What's the state's position on bond?
Your Honor, we have Mr. Haas in Ironton Municipal Court on an aggravated menacing charge and a theft charge involving an individual that we're alleging that he stole items while he was supposed to be doing work in her residence, and also confronted her about it and menaced her in the meantime. Pretty contentious situation. Now we've got him accused of doing this as well. So we feel that it's deserving of a cash or surety bond. We ask for $5,000 cash or surety.
I'll set bond at $5,000 cash or surety. Set the next hearing for the 17th, August 17th, for a pretrial at 10 o'clock.
State of Ohio versus Virginia Johnson, case number TRC 261382 A and B, CRB 14141, TRC 133196 A, B, and C.
Your Honor, Mr. Haas was Mr. Steyer's case, which was
Correct.
What was that date on that?
17th.
8/17?
Yes. Ma'am, are you Virginia Johnson? Case number is 261382. There's some old cases, 14141, where it's alleged you failed to appear for a review hearing. Also 133184, failure to appear for a review hearing. The new charge alleges August the 6th at 4:32 p.m. Fayette Township, you were allegedly driving a vehicle under the influence of alcohol or drugs, and that this would be your second offense within the look-back period. Second offense, the maximum penalty is 6 months in jail, $1,625 fine, and a 7-year license suspension. The minimum penalty now is 10 days in jail, $715 fine, and a 1-year license suspension. You're also charged with failure to maintain and assure clear distance ahead while driving, which usually means you ran into something, another vehicle. That's like a speeding ticket. It's a minor misdemeanor, the maximum penalty is $150 fine. Do you understand these charges? Do you understand the rights you have? Did I explain your rights? You have a right to remain silent. You don't have to say anything. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state of Ohio prove the charges beyond a reasonable doubt. You understand those things? How do you want to plead to these new charges from August the 6th? Guilty?
I'm on methadone.
Okay, well, what plea do you want to enter? They're alleging you were under the influence of alcohol or drugs or a combination of those things. How do you want to plead to that? Okay. And then you've got an allegation that you missed review hearings on old cases. One was a theft offense, and the other one looks like an OBI. Yeah, it was an OBI. So I'll enter a not guilty plea to everything. I think we need a cash bond, since she has a history of not appearing previously, and this is a second offense. So I'm going to set your bond at $3,000 cash or surety. Do you think you can post that bond? Probably.
300.
You want to talk to the bail bondsman?
Yeah, do you take credit card?
I don't take anything. You have to talk to the bail bondsman. It'll be between you and him. So the bailiff will give you his contact information. The one that does the most, you can use anyone's approved, but the one, Gary Sowers, does most of the bonds around here, and he's easy to get a hold of. Okay, so do you want a court-appointed lawyer? Are you working? You have no income? Let's see. Your old cases are so old, you had David Dillon on one and Mr. Smith on the other, so neither one of them are still practicing. So, Mr. Stratton, I'll appoint you. Ma'am, you think you can post the bond?
I'm going to do my best.
Okay. You don't have to. I assume you're the mom.
Yes.
There's nothing that says you got to post bond.
Right, I understand.
Okay. If she's going to sit in jail, I'll set her hearing earlier. She's going to get out. I may go longer before we come back for another hearing. That's why I'm asking.
Like I said, I'm going to do my best to contact the bailiff and I heard.
Bail bondsman. Okay, let's set it 24th. Let's see. Yeah, no, that's a bad day.
That's that day.
Okay. 21st.
21st.
August 21st. All her cases are set for August 21st.
State of Ohio versus Sarah Lynn Ratcliffe. Case number CRB 26485, CRB 2864, CRD 14557, CRD 14179.
Ratcliffe. Okay, we've got some old cases and a new case. 26485 is a new case. Before we go over it, I'll go over your rights. You have the right to remain silent. Everything's being recorded here. So whatever you say comes out of your mouth, you're stuck with it. You don't have to say anything. But it is on the record what you're saying. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, and to make the state prove this charge beyond a reasonable doubt. Understand those things?
Yes.
Okay, so let's go over the charge. It's a theft offense from Walmart. It alleges August the 6th, Fayette Township, you tried to defraud Walmart of property without their consent. It's a first-degree misdemeanor theft, maximum penalty 6 months in jail, $1,000 fine. You understand that charge? Now you plead to it. Okay? Come back to that. Then I've got another case, 20864. It's an old case, but it's alleged you never appeared. And it was, looks like fishing without, no, a dog. Dog not having a license. It's from the dog warden from back in October 23rd of 2020. And it looks like you were ordered to appear in this court on October 30th, 9 a.m. and failed to appear. A warrant was issued in for not appearing. That is, the allegation was, I received a complaint about a defendant's dog running loose, searched for the dog, got more complaints, found where the dog lived, she did not have tags, given a citation for failure to license. Okay, so that's pending. Then there's 14557. That was a driving under suspension. Actually, it looks like that was yeah, what happened was you failed to appear for a review hearing in January 20, and then in February of 2021, somebody paid off your fines for you, so it's been paid after the fact that the warrant was issued. And then in 14179, looks like at the same time they paid off that one too. So those, we'll just ignore those two. They've been resolved. So the only two you got is that dog ticket from 2020 and the new charge, which is the theft offense.
I also have 21 CRB 425, which is a theft offense.
I don't have that one. Let's get that. What was the case number?
21 425.
21 425. Okay. 21 425. Oh, it was passed because she was not, according to what I'm reading on the computer, passed for service. She was served by a resident service, which is not sufficient. Okay, as soon as we get that file out, I'll have you come back out. We'll go over it. 21 425.
State law versus Destiny Lester, case number CRB 26276, CRA 26277, A and B. This case.
All right, this is actually Mr. Smith's case. It's set today. pretrial. Destiny was. So, she had a warrant from June 5th for failure to appear. She was supposed to go to Southern Hope then. I don't know if she did.
Your Honor, I picked her up from the jail per your orders on May 22nd at 4:15 p.m. Dropped her at our agency. She left on 5/23 at 4 o'clock a.m. We never got an opportunity to access her. She wasn't even there 24 hours.
Okay. What's the state's position for Ms. Lester?
She say something about it.
She said she wants to go back to treatment, and she's willing to even do an ankle monitor if that's what it takes to get her
Well,
there.
I think it's quite generous of her to suggest that.
Yeah.
I'm not trying to have a baby in jail for prison. Doesn't matter.
If somebody would take her, now she still has these charges pending, the theft charge from Walmart, which, you know, that's something that we're not going to overlook. We're happy for her to have an opportunity in treatment and to get rid of those felony charges, but we're going to have to reckon with this theft charge, and it certainly would, in my eyes, help her cause if she would go ahead, if she is guilty of that, to go ahead and plead guilty to it and be done with that. If she needs to have a trial, we can do that too.
Okay. So we're going to keep, it's actually a trafficking charge. It's for trafficking in drugs. It's an F4 though, so.
And it's not the kind where they, you know, actually catch someone in the act of trafficking. It's more like she had baggies in a scale with her.
Okay.
So
That's pretty good evidence though.
it is.
Okay, so I'm going to accept your guilty plea on the 26-276 to theft. I'm going to delay sentencing, let you go to treatment, and Southern Hope wants to take her back. I'm going to order she have an ankle monitor, so I don't know if it'll happen today or not. It may not.
I'm totally on board with that.
Okay. So here's what you need to understand when I put an ankle monitor on you. It really ups the ante because the ankle monitors are so good now. And now, can we get one?
It's not that, Your Honor, but Carl Bowman doesn't allow people to go to Southern Hope.
Okay.
Why is that? We're on their approved list and we have people sitting in their court.
That's the last word I heard, Your Honor.
Okay.
Okay, that has changed.
I mean, I can check.
Okay, all right.
That was the last word.
Provisionally, I'll order it, and if they'll agree to it, but she does have to have an ankle monitor, so, because she failed to appear. She left treatment once before, so back to my speech about the ankle monitor, because this really ups the ante on what happens to you. You can't leave because they know exactly where you are at all times. So if you got an ankle monitor on, within a few feet, they know where you are. So that the only way you can get away is to cut it off, which is hard to do, but possible. So what happens if you cut the ankle monitor off? When they eventually get you back, it's going to be out of my control. You're going to go down to the common police court, the felony court, and they are going to send you to prison. No ifs, ands, or buts. It's not like your mom when she says, I'm going to do this to you. If you do that, and then they back off. No, this is going to happen. You are going to go to prison if you cut the ankle monitor off.
I understand.
You understand? It's not a joke. It will happen. Everybody that's I've had a few do it. They've all gone to prison for at least 3 years because they're going to try to make an example of it because they don't want people cutting ankle monitors off. So.
An OR bond, John.
2000 OR bond. And and Southern Hope with GPS monitor. Let's put her back on the docket for Monday just to check to make sure it happened, and if not, we'll make different arrangements then.
I think it says that Mr. Smith is going to be here.
Okay. It is his case, right?
Is that correct?
It's not one of the dates listed, it's not available, so. Roger Smith. So, yeah, we only got one lawyer today, and it's Mr. Stratton. It's a dying breed. If anybody wants to go to law school, now's a good time to do it. We don't have any, we're running out of lawyers. It's true. Okay, August the 10th, if you get out today, we'll get a report on you. If you're still in jail, we'll make it happen on Monday that you go. Okay? You gotta take care of business this time. No playing around. You're done. It's gonna be serious consequences. Serious going to. You don't look like the type of person that would do well in prison either. So you gotta avoid it. You gotta do what you're supposed to do. Okay? You understand me?
Yes, sir.
Okay. That's all.
State of Ohio recall Sarah Ratcliffe. Case number CRB 21425, CRB 2864, CRB 14557.
Okay, so we were looking for another file, I guess we got it. Okay. She was never served with these charges, so let's go ahead and serve her with those. They're old, but you never got served with them. And it's another theft offense. And it alleges that on May 26th of 2021, in Rome Township, you purposely tried to deprive Kaylin Cabrera of property without her consent, being an EBT card. It's a first-degree misdemeanor theft offense, maximum penalty, 6 months in jail, $1,000 fine. Do you understand that charge? May not be true, but do you understand it? I think this was your grandmother, I believe, from what it says.
My grandson's mom.
Okay. So what's the state's position on bond on all of these? And I guess we need a lawyer for you. Well, how do you plead?
Not guilty.
Not guilty on this one, so.
Did she plead guilty to the current, the
She
latest?
pled no contest to one of the more recent ones, so
Well,
not guilty on this one. But she's got a history of not showing up.
well, and also, I guess, probably the court's gonna require her to do a drug screen, so maybe that have some.
Well, if I'll go ahead and censure on the other one, I guess I could. Well, what if you do a drug screen, what's it gonna show? For fentanyl? Do you even know that for sure though?
Yeah, I'm hoping.
I had people all the time testing positive for fentanyl, but didn't know they were getting it. If you're getting anything off the street, they could have fentanyl in it. That's just a fact these days. Are you interested in going to treatment? It's better than jail and it'll get you clean. You gone to treatment before?
Yeah, on my own.
On your own, not court ordered?
No.
Let's have you do a screen first, see what we're dealing with. Go do your screen, we'll come back and decide what we're gonna do on your treatment options. I wanna know what's in there. So we'll recall this after your screen.
State of Ohio versus Linda Sloan, case number CRA 26454, A and B. Also Mr. Smith's case.
Okay, now I remember This is the Kentucky. It's Mr. Smith's case, and he's not here today. Well, I think we just need to revoke your bond and let you sit in jail. Our OR bond is revoked. I'll set $2,500 cash and surety bond. Reschedule it for a date when Mr. Smith's going to be here. So, do it next week. No, we can't do that. It's a jury trial on the 14th. So,
No, we have intentions of changing.
it's not going to be a jury trial. Okay. So we can schedule for the 14th. Okay. August.
It works on Mr. Smith's schedule.
It does. He is available that day. So August the 14th for preliminary hearing and pre-trials for Ms. Sloan.
State of Ohio versus James W. Terry IV, case number CRA 26298. Set for arraignment trial.
Converting something.
Here's his liability, sir. You're James W. Terry. Mr. Terry, I'm Judge Capper. You have a right to remain silent. You don't have to say anything during this hearing. If you do say things, it's all being recorded, video and audio. So there's going to be a video of you saying whatever it is you say. It can be used against you. It's not off the record. You have a right to have an attorney, to have one appointed for you. Whatever you tell an attorney in private is privileged. It's off the record. What you say here is not. You have a right to have bail, and you have a right to have a court-appointed attorney if you can't afford one and meet the guidelines. You have a right to make the state prove this charge against you beyond a reasonable doubt. You understand those things? The state's alleging that on March the 18th of 2026 in Fayette Township, you knowingly obtained, possessed, or used methamphetamine, a Schedule II substance. That's aggravated possession of drugs. It's a felony of the 5th degree. It carries a maximum penalty of a year in jail, $2,500 fine. Do you understand the charge? I have no idea. It's the first time I've seen the charge. I don't know what the basis was. Yes. Charlton Hutchison, I'm just looking at the affidavit. It mentions that name in the affidavit.
Yeah, he said if I paid a ticket or a fine for the South Municipal courts, that I wouldn't have to come to court or something like that.
I don't know anything about that. So, do you understand the charge? This is the charge that's pending, and it's been filed for a while, May the 19th, 2026. Do you understand the charge? Do you have the money to hire a lawyer? You gonna hire a lawyer then? Okay. How much time do you need to do that? You have a right to have since it's a felony, you have a right, if you're in custody, to have a hearing within 10 days while you're in custody, 15 days if you're out of custody. So let's address that issue. What's the state's position on bond going to be for Mr. Terry?
Your Honor, it sounds to me like maybe there was a traffic charge or something that was left in mayor's court, and it was a bond forfeiture kind of, or, didn't have to appear kind of thing. I don't know, but this is a felony, obviously, possession charge, and what we would like, instead of him having to sit in jail we would like to see him be assessed for treatment. If he's got drug issues, and generally someone that's found in possession of methamphetamines may have a drug issue, then maybe he could get out of jail today. That's what we would prefer.
Are you interested in going to treatment, Mr. Terry?
Sure.
Do you have a medical card?
Do you got the paper?
He doesn't have a note.
My mom's here.
Are you working? Have you been working? Do you have health insurance?
No.
Yeah. How do you pay for medical services right now?
I normally just go to my parents.
Okay.
I work at McDonald's, Taco Bell, trying to get out of Wendy's.
Okay.
I don't know, do you got the paper?
Well, you may be eligible to get a Medicaid card then. Have you ever been to treatment before? You need treatment? If you're taking methamphetamine, you need treatment. It's bad stuff. Very highly addictive. It's not as dangerous as fentanyl, but the long-term effects are pretty bad. I take it that's a relative of yours, and she's saying, I heard her say he needs treatment, so she knows a lot more. I've never seen you laid eyes on you until just now. I have a lot of people that, in this court, that need treatment, so I'm very familiar with what's going on out in our community. It is an epidemic.
Say it again.
An epidemic of drugs. Okay. I've been here since before it started, and I'm here now in the middle of it. It's like nothing. If you told me 20 years ago we'd be having this, I would say, that you're crazy. We don't have a drug problem here. And now, oh my gosh, every court session, multiple people with drug problems. So you're not alone. There's a whole bunch of people that are in that boat with you. If you're doing meth, there's a whole bunch of people. It's probably the number, I'm going to say from my observations, the #1 drug in our community. Methamphetamine. It's everywhere out there. And it's bad stuff. So, what do you say? Do you want to go to treatment? They're saying, the state's saying, if you'll go to treatment, we'll agree to him getting an OR bond, which means you just sign your signature saying, I promise to come to court, I promise to go to treatment, do well, and I know this from the other cases, you do really well, your case won't even go to the grand jury. You know, felonies are so serious that a group of people, other citizens, have to meet in secret and hear the evidence and decide whether the state has enough evidence to even take you to court over a felony. That's what an indictment is. So you got a felony. If you want to fight it out, they're going to take you to the grand jury, get you indicted, and then you can go to prison if you're convicted. If you go to treatment and do well, you could get a dismissal. So you go from potentially going to prison to getting your case dismissed. That's two big differences, wide range. But you gotta do your part. You gotta do the work. You gotta go to treatment. You gotta get clean. The whole idea is for you to get clean and stay clean, not just avoid jail. So it's going to be a long-term thing. It's not like, oh, I can go to treatment for a month and then I'm done. No, because we know that that's not going to fix it. It's going to take a while.
My mom's here, can she talk?
No.
No.
You're a man. You got to talk for yourself. So you got to tell me what you want to do.
I actually want to get out today.
Nobody in jail wants to stay in jail, but that wasn't my question.
Treatment, just say treatment.
Do you want to go to treatment or you want to stay in jail and fight it?
Good treatment.
Okay.
I don't think I'm that up.
Okay, I think he needs to stay for a while. So I'm going to set your bond at $2,000 because now, you said the wrong things so far. I can see you're not ready to get clean. Because getting clean has got to be the #1 priority, and for you it's not. It's getting out of jail. For you, getting out of jail is the #1 priority, not getting clean. So you need a little more taste of the consequences. You got to have some consequences in life. And that teaches you to avoid the things that gave you the consequences. So $2,000 cash or surety bond. I'll go ahead and appoint Mr. Smith, give you his card. And he's available. We gotta do this, when did you come into the jail?
Wednesday.
Wednesday, okay. The 5th. So we gotta do this before the 20th. Okay. We'll do the 17th, August 17th. For a preliminary hearing, 10 o'clock. Roger Smith is going to be your lawyer. I would just urge you in the meantime, I don't know if your mom's going to post your bond or not, but if she does, you're out or in jail, think about, how old are you? 39, okay. You're a fully grown man getting old. This day and time, that's about equivalent, 30 years ago of, we treat 39-year-olds like a 25-year-old we do. But you're still a fully grown man. What do you want to do with your life? Yes. And if I'm an employer, which I have been for a long time, I don't want to employ anybody that's doing methamphetamine. And there's not very many employers that do. So you got to get clean. You got kids? Okay. He needs to get clean. And he needs to want to get clean. I'm not seeing it yet. Okay, August 17th will be your next hearing. If he gets out on bond, you got to get him back here for that hearing. He's in jail. I'll see you like this. You'll have the jumpsuit on. Okay. That's the next hearing, August 17th.
State will highway call Sarah Ratcliffe, case number CRV 21425, CRV 2864, CRV 26485, CRV 14179.
Okay, your screen was good. Okay, so the problem I got is you got all these other cases you didn't show up for. You want to give me an explanation why you didn't show up before?
A lot of them, I went to the post of moving, but it's not an excuse.
Well, I'm going to give you a bond, but I'm going to give it about as low as I can do. So $1,000, I'll let you out on $1,000 cash and surety bond. So probably $150 gets you out. You can post that? Okay. And you're not working, right?
I am working.
Where?
With International. It's out of Hardersville.
Paid by the hour?
Yes.
How much?
$11 an hour going for pay. I think my patient last for 2 weeks, $12.
I'll appoint Luke Steyer to represent you. And I will set your hearing on all your cases. So we can do the 14th now, not having a jury trial. August 14th.
Did you appoint an attorney?
Luke Steyer. So 1 week from today. You want a bail officer to get in touch with you? Okay, so we'll let him know that, and he's pretty good about getting in touch with you at the jail and getting your bond posted. Shouldn't take that long. So you should be able to get out shortly. But now if you don't show up, you know what happens. He's not gonna pay the $1,000. He'll be ordered to pay the $1,000 if you don't show up. He never pays. Rarely pays, because he'll come track you down. I don't care where you go. He's going to track you down, throw you in a car, take you to the jailhouse. She's shaking her head. She knows. She sees it all the time. So you gotta come to court now, there's no ifs, ands, or buts about it. August 14th, you gotta be back here at 10 o'clock.
I text Mr. Sauer, Your Honor.
Okay, thank you.
State of Ohio versus Jesse Ward, case number CRA 26480.
Have you been served with any papers?
None at all. They gave me one when they came to my home and said that I did not have a bond because I didn't show up to the first 4 days, and there was no first 4 days.
Well, this is a new charge, it looks to me like, yeah. So we'll need copies made. There's only one copy in the file. I need Mr. Cooper or somebody to come and give me a copy. Mr. Cooper.
He was served, that's when he was arrested, it was a warrant.
Okay.
He has been served.
All right, well, we got a record saying he was served. Okay, it's a possession of drugs charge. It's alleged on July 27th in Fayette Township, you knowingly obtained, possessed, or used a controlled substance involving cocaine. So that's a felony of the 5th degree, maximum penalty 1 year in jail, $2,500 fine. Do you understand the charge?
Yes, sir.
Do you have the money to hire a lawyer?
No, sir.
Do you have a job?
I did, before they picked me up, and they took me home.
Where were you working then?
Through notary, online notary services. Okay.
Okay. How much did you get paid doing that?
Not much, it depends on the services that they was providing, if they offer me per time.
Okay, I have to determine your gross annual income. Do you know what that is?
I just started it like 2 months ago, so.
Do you have children?
No.
Making less than $29,000 a year gross?
Yes.
What's the state's position on bond going to be for Mr. Ward?
Your Honor, this is one in which I believe I've received a little information from an investigator on this. I'll find it. Your Honor, this involved the Lawrence County Drug and Major Crimes Task Force, and I believe that there are additional charges that are coming as well.
Okay.
So we would ask for a $10,000 cash or surety bond.
Okay, I'll set bond at $10,000. I'm going to appoint Roger Smith then. When did you get arrested, sir?
This was like 2 days ago. They came to my home, they got me, my house is unlocked. There's no, I haven't even, this drug force pulled me over and asked me some questions about some people in my neighborhood that I do talk to. I'm not going to say that I don't know these people, but I have nothing to do with their personal business and what they do. So they told me if I didn't come up with the answers to these questions that they wanted, then it wasn't going to be good for me. And I'm like, well, how did I even get put in this position? So I talked to them on and off for like a week.
Sir, let me caution you too that this is all being recorded, so everything you're saying is on the record. So if you admit something about your case, this guy right here can play that video later in a proceeding to say, well, he said this on August the 7th. That get played. There is a video of you saying what it is that you're saying. So I don't know if that'll be important in your case, but I think if you talk to your defense lawyer, he would say the less said on the record is probably best. So, and they say there's more charges coming, so I'll set what was requested, 10,000 cash for surety, appointed you a lawyer. I'll set your hearing for next Friday, August 14th, preliminary hearing then. If you make bond, you gotta get yourself here then. If you don't make bond, the sheriff is required to bring you for the hearing. Okay.
What's that date, Your Honor?
14th, 1 week from today.
State of Ohio versus Scott Gillespie, case number PRC 261108, A, B, C, and D.
I got an email from them earlier in the meeting, I just emailed them back, probably. I told them.
TRC 261108. Okay, this is for pretrial. I guess he's been in jail for a while. Oh, okay. We were, one of the things, well, we probably don't have it yet. There's a urine screen out there, but I don't know, we probably don't have that result yet. Let's see, July 2nd. No, we won't have it. It's been over a month, so.
Probation is waiting on the resolution of this case, Your Honor.
It's common police probation. Oh, they're waiting on this one, so we're probably another month out before we get our screen back.
At least. Well, that's what it is.
So just set up for the pre-trial.
Okay. Well, it looks like with Mr. Steyer's schedule, the 14th may be the first, yes, the date's at the beginning of the month, it's not available. September 14th, and that probably is about the time the urine results are going to come in. Okay. September 14th will be the pre-trial, 10 o'clock. 2,500 cash surety that. I think he's got a holder from common police probation, so that's why he can't get out.
And Your Honor, I would be willing to contact the Bureau of Community Corrections today to see what they wanted out of him. That maybe.
Treatment, maybe.
And that's a possibility, I don't know that, but I can at least check and.
Okay. I mean, I would be amenable if they serve, he's been in jail for a while. If they would be willing to lift the holder, let him go to treatment, I'm okay with it too.
State of Ohio versus Seth Harrison, case number CRB 26353, A, B, and C.
So, Your Honor, he has been considered to engage with, but it's based or it's based upon the evaluation. Do you have a report there, Your Honor?
Don't believe so. I don't see one. I don't see any of the paperwork for it, so.
We were here on, I believe, the 17th.
Yes.
That's where we had talked about having that done. So
she is. She's watching me on my phone, my camera be like 66 or something like that. That's how you found me to arrest me. And that's the only way she feels threatened is because she's listening to me talk when she should be listening to me talk.
Okay, if there hasn't been an order, I'll enter the order
I'm not.
for Southeast Ohio Forensics.
Send anything to.
I never want to see her again.
We have discussed,
I fired you. Okay.
sorry.
The state agrees that Southeast Ohio Forensics should be
Yes.
engaged. Okay. We'll do an order to that effect, to set a new hearing.
If the jail had things
That could override it.
but ADH could not even be anyway.
But the problem, you weren't, were you in on that? We had a teleconference with the director at ADH.
I was
And it sounds like he's getting all these pink slips, and he's going through them and saying, not valid, not valid, not, I mean, there's only 92 beds for 17 counties. So it's hard to get somebody in there. I mean, so he's trying to eliminate, well, I mean, we're sending them pink slips, and he'll look at them and try to, he can't take them all, so he's throwing some of them out. So I don't know if that's what happened here or not, but. I'll go ahead and order the forensic evaluation.
Your Honor, is that, would you look in the computer, see if that's how you list the word?
And consider not guilty by NGRI on him or? Okay. Also bad evaluation too, not guilty by for reason
We do that at the same time.
Yeah. And then I need the date, right? Did I give a date?
I think you said 9/14.
I did not give a date. It'll take at least a month. 18th of September. That's not on your
that's good.
disapproved list. Okay, we'll do that too. But what's happening is, what I just found out, you get a pink slip, then I'll make them email accept. I guess, yeah.
State of Ohio versus Jason Taylor here at the court. Case number TRC 172266 A and B. That's all the deal.
All right, Mr. Taylor is here.
Yeah, I was supposed to be here Monday, but my girl's car broke down. I called Mr. Major and let him know I'll be able to make it here today.
Okay, so this is on review.
Yes, sir. I got a payment too.
And your community service is all done, so that's all you gotta do is pay off.
Yes, sir.
How much are you paying today?
I got 40 today, and then when I get paid next week, I'm gonna pay some more.
Okay.
And for my next court date, could you make it a Friday, because they switched my off days around.
Okay, it's going to be September 25th.
Thank you.
See you in the park.
I will.
State of Ohio versus Jasmine Green, case number CRB 26374.
This is Mr. Stratton's case, pretrial. Was a pretrial on July 31st. Looks like
It's your husband.
she did not appear then, so it's not on the docket today.
She's the one.
Okay, what? Just look at my notes.
No, she was supposed to be last week.
Do you have an explanation for not appearing on the 31st?
Yeah, my car got towed, but I got it back next week. I got it back on Monday.
I didn't hear what you said.
The car got towed.
Oh.
There was a flat. I hit a pothole. I did call it.
So what can we do on this case? It's been pending since June. Is there a plan on it?
If we had a chance to come back one more time. Okay. All right. So we had communication with the alleged victim in this matter, and she told us that she was moving 1,000 miles away and didn't want to take part in the case anymore. And our response was, well, email us something in writing that says that, so we have a record that that's your wishes. And she, despite repeated efforts to ask her to do that, she hasn't. I think at this point we could nolly this with the right in the unlikely scenario that we would need to refile it. It probably would never happen, but we would like to preserve that right anyway.
Assume there's no objection to that.
No, Your Honor.
Be nollied with the right to refile.
That's it. You're done.
That's it?
Yep.
Pretty good.
All right. That's it?
Yeah.
Oh, thank you.
It's been dismissed.
State of Ohio versus James Cook, case number TRC 26756, A, B, and C.
Your Honor, I need to get some information from and request some discovery from the state. This was set for trial next week. The state and I thought we did an entry continuing that jury trial. I couldn't find my copy. I don't think the state has their copy, and we couldn't find the copy in the file or the electronic file. So, might have been just
dreamed it.
Maybe we dreamed it, but we'll just like to convert the 14th into a pre-trial. That's good with the court.
Your Honor, I would like to say that the jury notices have already gone out. Is there potential that it will be a jury trial again at a later date, or?
I don't anticipate that, Your Honor.
Okay. So we'll need to notify
So when they will notify
the jurors that they don't have to come in now, because some have been served already. Okay, so cancel the jury trial for the 14th, and you want to keep it as a pre-trial that day.
Yes, Your Honor, we'll keep it as a pre-trial that day.
Be converted from a jury trial to a pre-trial at 10 o'clock on the 14th of August.
Yes.
What about the paper trap?
Oh, yes, Your Honor, he is asking for driving privileges.
It's a pre-trial.
I think it's a third offense, isn't it? It's considered a third offense.
It's a second and 10 with a refusal and an additional in 20.
Well, that's, yeah, last one. want to say the last one was an 18.
The last one was an 18.
Yeah.
And then
I have to look at the chart the way you're looking at it, Your Honor, so.
Well, here's what I'm seeing with that level. Plates required, interlock required if alcohol was involved.
Okay.
So you've got to get the special plates, and you've got to have the interlock before you can, and it's got to be more than 45 days.
This is May 15th, I believe it was. So it's more than 45 days.
May 10th.
May 10th, yeah, sorry.
So he could talk to Mr. Major about the interlock if he's interested in that. He also has to go to the B&B and get the special plates put on his vehicle.
Prior to the court order. Okay. Yeah. So you can talk to them about that before the 14th. And we'll see if we can do it on the 14th. We got it resolved. Okay? All right. Just go talk to Mr. Major about it.
Okay, so this is on the docket for the 14th as a pretrial now.
You're going to file for discovery?
Yeah.
State of Ohio versus Mariah Hannah, case number TRC 26755.
Yes, Your Honor. Drake Hannah, we got the results today on the OVI. And at this time, we're going to plead guilty. Waive statement of facts, stipulation of appeal.
Okay, so what were the results?
THC, cocaine, and the cocaine metabolite.
Yes, Your Honor.
Okay.
Yeah, we've got a copy for the court, Your Honor.
How do you pay for medical services?
I have a medical card.
Ohio?
Yeah.
Well, I'm going to, and it's not just me, it's required that you get counseling on this level of offense. Well, that was the first. But I'm still going to require cocaine in your system, you need to get some counseling. I was thinking there was a prior.
Case number again, Your Honor.
Case number is 26755.
Thank you.
I'll let you do it on an outpatient basis. Anything you want to say, either you or Mr. Stratton, before I sentence you? You have a right to make a statement.
I have nothing further to say, Your Honor, unless Drake has anything to say.
No.
Okay. Okay, well, this comes under the new provision, so I'll give you the minimum fine now, which is bad enough, $565, that's the new minimum. $565 fine, court costs, 1 year license suspension, and that starts today, not the date of the offense.
Yes.
$20 days in jail and I'll suspend it. 5 days of community service. I'm going to require that you go to the driver intervention program and do outpatient counseling. Code for cocaine. You live Proctorville.
Not anymore. I live in Ironton now.
You live in Ironton?
Yeah.
Okay. Who's got an office in Ironton? Okay, so, Ms. Lewis will talk to you about getting, and I'm okay with him going to outpatient.
I'm sorry, I did outpatient with what agency?
Hometown service.
Additional community service for the court costs? Okay, all right. That's what I thought you meant.
Set a review hearing for October 2nd. So that's, I'll find out what you're doing on your treatment. 9 o'clock.
Well, just whatever.
It's turn signal violation, $10 fine.
I didn't check too. Yeah. Just go talk to Mr. Major, but this is review date. It's at 9 though. Okay? All right, Drew. We're good?
Okay, you have 2 people to meet with, the probation officer and the treatment person, and then you're free to go after that. Any questions of me?
No, sir.
Okay.
Is there a request for a permit?
Oh, yeah, I can give you a permit to drive if you want. I assume you do.
Yeah, definitely.
I can, well, if it's not alcohol related, so it'll be a limited driving privileges for, are you working?
I will be soon.
Okay, for employment, to go to treatment, to come to court, to go to community service. Those are the reasons you can drive. You'll get that from your probation officer.
Right, we're there. Okay. All right.
I can make it good just till the first, we need to start renewing those at the review hearing, so it's good until October the 2nd, and then if they don't show up, I don't want to still have a permit to drive.
State of Ohio versus Roger Dale Johnson, case number CRB 26296. This is set for trial Tuesday.
All right, Mr. Johnson, are you represented today?
No, I'm representing myself, Your Honor.
This is set for trial today.
Yes,
You
Your
can
Honor.
walk the chair there, sir, and have a seat at the table.
You may pull up the chair.
Yeah, got it. Same ready to proceed?
Yes, Your Honor.
And you're ready to proceed, Mr. Johnson?
Yes, Your Honor.
Okay. You have any opening statements you want to make, Mr. Heel?
Well, Your Honor, I will on this occasion. Your Honor, this is a situation, I think the evidence is going to be that Roger Johnson and Wendy Johnson had just recently been divorced, and the court, as part of their separation agreement, set a deadline for him to get his personal belongings from the residence, and the residence was being awarded to Wendy Johnson. And the residence includes an outbuilding that Mr. Johnson, I believe, thought was that, well, that's part of my personal belongings and I can take it. Well, instead of taking it, he goes and drives a school bus onto the property where he doesn't live anymore and destroys the building by driving over it with the school bus. He destroys the building, which is, I would argue, is not removing personal property, it's destroying a fixture or a part of the real estate. So we charged him with criminal damaging, and I think that the evidence will show that. We're going to have a video that shows it happening, and we've got witnesses. And quite frankly, what he did was, if he was supposed to be taking his personal property, and he considers that personal property, he didn't take it. He left it in a heap in her yard. And it's just deplorable, despicable. I'm sure he's just bitter over the divorce, and that's what he chose to do. And I think we can prove quite clearly that he's guilty. And when we were here before, we offered a very reasonable solution to the problem, and that would be that he would pay for her to have it removed, the wreckage removed from the property, and pay court costs, but he wouldn't do that. So that's why we're here today.
All right, Mr. Johnson, you have a right to make an opening statement if you want. This is not evidence, this is just tell me what the case is about. So, do you want to make an opening statement?
Yes, sir.
Okay, go ahead.
Most of what he's saying is false. He doesn't have the facts. On my divorce, it says by May the 1st. Every time I went and tried to retrieve my property, I was harassed, I was smacked, the cops were called. Every bit of my clothes, I never received nothing, were thrown out. and burnt on May 1. The video that he is referring to, the person that took the video showed up, she has half the evidence. I was trying to pull the building out between the trees, the building started collapsing. The building was not attached to the ground, it was my personal building. It was a bar that I was actually living in, I've been living in for some time. The school bus belonged to me. I bought it at an auction. We live on a private road. I was taking it down the private road was my intentions to a property that was safe that I can store it on. That she had went in and damaged, which I have pictures to prove everything, and the bragging rights of everyone, that they destroyed Rogers Bar. Here it is. I went and I had a bar set up inside, and I had tanks. I had CO2 tanks. I had carbon dioxide tanks. I had helium tanks. I had argon tanks. She went in and knocked them all over with the taps and everything, and it made a hazard. So when it started shifting, I had to run the bus into it. That's the only means I had at the time to bring it down for safety issues.
All right, thank you, sir.
Yes, sir.
Mr. Hill, you can call your first witness.
We'll call Wendy Johnson, Your Honor.
Sir, you can have a seat.
Yes, sir.
Yeah, over here.
And if you come up to the witness stand, I'll swear you in. Raise your right hand, please. You swear the testimony you're about to give shall be the truth, the whole truth, nothing but the truth, so help you God.
Yes.
You may be seated.
Ma'am, are you Wendy Johnson?
Yes.
And let's see here. You live at 541 Township Road 1010 in Chesapeake, Ohio?
Yes, right now.
I'm sorry?
Yes.
Now, who lives with you there now?
My brother.
Was there an incident at the residence on May the 1st of this year that caused the Lawrence County Sheriff's Office to become involved?
Yes, I called them.
And did that incident involve Roger Johnson?
Yes.
And who is Roger Johnson to you?
Ex-husband.
Were you all just recently divorced?
Yes, it was final April 14th.
Was there something about May the 1st that was specific to your divorce agreement?
That his stuff was supposed to be removed by then. He never come and got nothing.
I mean, it sounds to me like he's going to say he tried to stop him from getting stuff. Did you ever stop him from getting anything?
No, I never did. He called the cops every day. They said there was nothing they could do.
Was one of these items that maybe he wanted or was contending a building of some sort?
Yes, it was the building where, yes,
A building where what?
he cheated with the neighbor.
Okay. Is that what led to the divorce?
Yes.
So was this building something that was part of the property?
Yes, it was on my property.
And in the divorce papers, in your agreement, I assume you have a separation agreement where you agreed to divide everything up?
Yes. we
Was the
have an
building
agreement.
even mentioned?
No. The building ain't even on the divorce papers.
And were you awarded the residence in the divorce?
Yes.
And there's a mortgage on the residence?
Yes.
And you were going to finish paying it?
Yes, that's what I'm trying to do. Yes.
Okay. I'm going to show you what I've had marked as Exhibit A and ask you if you know what this document is.
That's my divorce paper.
And is there a separation agreement attached to it?
I think.
I guess I shouldn't ask you how the one gave to you, right?
Yes.
And is that the separation agreement?
Yes.
Okay, so I'm sure you're familiar with that. And it says in there that he had until May 1st to come get his stuff. And done something about the outbuilding being a piece of personal property.
No, it is a structure on the property.
Did you plan on continuing to have that building on the property and use it?
Yeah, I was gonna move stuff from one building into it.
So what happened on May 1st?
I was at work and I come home and it's laying on the ground.
And first,
I had no idea, no. And then my neighbor was home and she said that he had drove through it. Just backed into it, drove through it. Yeah, 3 times, not once.
what did you use to drive through it?
The school bus.
Did you end up getting video of that?
Yes.
And Your Honor, I'm going to ask you to this decree marked as Exhibit A.
Any objection, Mr. Johnson?
Yeah, I'd like to see it, sir. See what they're giving. Okay, now what do you want to do?
Admit it as evidence. That's the divorce decree and the separation agreement.
Okay. May I have a few minutes to look over this? Because to make sure that it's exactly what it is, sir.
I assume you've seen the divorce decree and...
I have the original copy here,
Okay.
and I just want to make sure it's the same, make sure what I agreed to.
I'll give you a couple minutes to look at it.
Okay.
Your Honor, I'm going to need to have John or somebody set the thing up so I can show the
Okay,
video.
we'll get him in here then.
Okay. Mr. Hill? Whichever one you want.
Okay, I'm done,
Oh, is he
sir.
the one that has it?
No.
No.
Oh, okay, yeah.
I'm done, sir.
You have any objections to that?
This is Mr. Thunder.
There is one page that's not included in the original on the back, but it's just a notary signature, sir.
I didn't understand what you said, sir. There's one page what?
There's one page not included on the original that's on the very last page, but it is just a notary.
Oh, yours doesn't have the notary?
It has the notary, but not that back one. The page right in front of it does.
It looks like it's just been copied twice, so.
Yes, sir.
Subject to that.
Yes, sir.
It's the same thing.
Yes, sir.
So it's, it can be admitted. So we'll mark it as, okay, it's Exhibit A for the state.
Yes,
Be
sir.
admitted.
Yes, sir.
And I didn't ask you, is that Roger Johnson in the courtroom here
Yes.
today?
Yes.
Your Honor, we'll go ahead and turn this off.
Okay.
So is that the video you received?
Yes.
And is that the building that we're talking about?
Yes.
And this school bus, do you know how he got a school bus?
Well, he works for the Cabell County Board of Education. He's over transportation. But he obviously bought it, or it's been on that road for, ever since he did that, before he did that.
So you knew him to have this school bus?
No, he wasn't with me when he had that bus.
Okay, but you didn't know he had a bus until this happened? Or did you already know he had a bus?
We already seen it sitting down the road.
Did you give him permission to do that?
No.
And, Your Honor, I'm going to ask that video be marked as Exhibit B in a minute. That is your building being torn down now?
Yes.
Any objection, Mr. Johnson?
Yes, sir.
What is your objection?
The building does not belong to Mrs. Johnson. It is my personal belonging.
Okay, that'll be, but you're not objecting to the evidence, you're just objecting that.
I am objecting, that's not the full video, sir.
There's 2 more videos.
Uh-huh.
All right, overruled, I'll admit it, exhibit B is admitted.
Do you have an estimate of the value of that building, the amount it would cost to replace it?
No, I have no clue about that building, except it was an outbuilding.
Previously, we discussed that you would like to have $500 to rid yourself of the wreckage.
Mm-hmm.
Is that an amount that you would be satisfied with
Yes.
restitution? Is it still, the wreckage of that building still on your property?
Yes, it's still sitting there.
Has he ever offered to come and clean it up?
No, he won't speak to me. He don't, no.
That's all I have of this witness, Your Honor.
Do you have any questions you want to ask the witness, Mr. Johnson?
No, sir.
All right, ma'am, you may sit down.
We'll call Corporal Orsbon.
Corporal Orsbon. Call attention. Good afternoon. Would you raise your right hand? Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may be seated.
Corporal, state your name and where you were employed.
I'm Corporal Shannon Orbon, Lawrence County Sheriff's Department, Lawrence County, Ohio.
Were you working on May the 1st, 2026, and were you dispatched to the home of Wendy Johnson in the Chesapeake area regarding damage to a building on our property?
I was.
Did you meet with Wendy Johnson?
I did.
And did you get an explanation from her about why you were called there?
When I arrived, I spoke with Wendy about what was going on. Wendy stated that she has talked to some neighbors and had some video of her soon-to-be ex-husband, or ex-husband Roger, backing over a building, damaging the building and the school bus.
Were you wearing a body camera that day?
Yes, sir.
And was it working and the video preserved?
Yes.
All right, so now I need to do this. So what's the time saying?
The time's 10 seconds.
On the start.
Video.
Okay, so what's this?
Hello. How are you? How are you? Oh, not too bad.
Me and my husband are divorced.
Okay.
He had till by May 1st, his personal belongings was supposed to be off my residence. Okay, that building's not personal belonging. That woman, there's a woman and that one also. Then the people in the red double wide, they've got videos. He drove a bus through it. That's what I said.
So, is this, yeah, is this the,
Divorce decree?
yeah.
Yeah, I thought
So he had until today to get everything out?
he had till last night, 5 first.
Okay. Yeah.
And I thought I was done with it.
Right.
Yeah, he goes through. Every one of us. They said it one way or another. And
Well, let me move out of the way so they can get by.
All right, so, on that video there, was that a true and accurate recording of the conversation that you had with Ms. Johnson when you arrived?
Yes, sir.
Now, did you go and take pictures of the,
I did. I took pictures of all of the building, tire tracks, things like that.
I have just 2 so far?
Yes, A and B.
So I'm going to mark this as Stacy's at C. I'm going to ask you to tell me what that is.
This is the building or outbuilding that was currently setting on the property, Wendy Johnson's. The school bus went through.
You took that picture,
Yes, I took this picture.
and that's a fair and accurate representation of what you witnessed
Yes, sir.
on May the 1st of 2026?
Yes.
Yes, sir.
And I'm going to ask that Exhibit C be admitted, Your Honor.
All right. Any objection to C, Mr.?
No, sir.
Be admitted.
Did you go and, did you find out where the school bus would be and go investigate that?
I did. After I took pictures, got statements from Wendy and the other people who witnessed it. I got, spoke to the neighbors, got statements from the neighbors, and then after I cleared from there, I went to the house where the bus was parked.
And how did you come by the information about where you would find that bus?
As you're coming onto the road, there's a bus parked, a school bus parked there. When I was speaking to Wendy and the others, the neighbors, they stated that the bus was parked just a few houses up. And that's where Roger Johnson was living at the time.
And did you observe the bus?
I did observe the bus. When I knocked on the door, no one was home, no one answered the door. So I started to investigate and check to see if there, because there's two different places there. The bus was set on like a lot beside the house. So I went to the little building that was there, knocked on it, and checked it. And I had any contact with anyone.
Did you notice any damage to it?
There was some damage to the back of the school bus. You can see there was some damage at the back of the bus.
Was your your body cam operating?
Yes, sir.
So, was that the video from your body camera?
Yes, sir.
And it was an accurate depiction of what you observed?
Yes.
And the bus itself, did you see damage on the bus?
I did. I shined the light on the damage. There was some damage to the back of the bus, the license plate. I looked at the bus to see if it was the same bus that was identified in the video.
And did you confirm that?
Yes.
And did the damage to the bus appear to be consistent with the...
As far as I can tell, it was, yes.
And I'm going to ask that these videos be admitted as Exhibit D.
Okay. Any objection, Mr. Johnson?
No, sir.
He admitted.
And that's all I have, Your Honor.
Do you have any questions for the officer, Mr. Johnson?
I do, Your Honor.
Go ahead.
Hello, Mr. Horton. How are you?
Good, how are you?
Doing well. So, you spoke with my ex-wife, Wendy, as we sing
Yeah.
on your video, but you also wrote a statement, correct?
I did. I
Okay. Was that admitted?
It should have been in your report. There's a statement in there.
To me, does prosecution have it?
You should have it.
Should have a copy.
Okay.
Yeah.
All right. If you don't care, I'd like to read something here that, from you. Or let me show it to you. Can I do that? Make sure it's yours?
You can't approach the witness.
I can.
You can, and hand in the documents when you agree.
This is the criminal affidavit from the narrative that I took on the report. What do you want me to read off of?
I know, I just wanted you to read that that was yours.
Oh, yeah, yes.
That is your statement.
Yes, sir.
Okay.
Yes.
Can you see this, sir?
No.
Okay. Your Honor, it says, Mr. Orton just read it. We all know that he read it and said it was his. He's
admitted into evidence?
Yes, sir.
Any objection?
Yes, sir.
I'm asking Mr. Beal if he has any objection to admitting officer's statement into evidence.
No, Your Honor.
Be marked as defendant's exhibit 1 and admitted into evidence. So if you want to bring it up to the clerk, she'll mark it and
Okay.
it'll be admitted. Do you have any other questions or anything?
Yes,
else?
sir.
Go ahead.
The paper that you have there in front of you, we just submitted into evidence. It says that Mr. Orsman come to my residence where I live and tried to contact me, which is, it's not true at all. Where the bus is setting
You
is
have a question, sir. I know you're not a lawyer, but you're going to get to testify, so you don't get to testify now. You can ask him questions.
that's what I was asking him.
You're saying it as a statement. You got to do it as a question.
Okay, Mr. Orsman, did you come to my house and try to find me?
That was the residence that I was given you were staying at, yes.
Okay, who were you given the residence by?
And Wendy, your
Okay, okay. That's it. That's all I have, Your Honor.
Any redirect?
No, Your Honor.
You may sit down. Is the officer released then?
Yes,
Thank you. You're
Thank you,
released.
sir.
and the state rests. Thanks, Corporal. Appreciate it.
All right, it's over to you now, Mr. Johnson. Do you have witnesses that you want to call, or do you want to testify yourself?
No, I have witnesses that I want to call.
Okay, call your witnesses.
I'd like to call Mrs. Bailey.
Okay. Bailey, come up to the witness stand and I'll swear you in. You would raise your right hand, please, ma'am. You swear the testimony you're about to give shall be the truth, the whole truth, nothing but the truth, so help you God. You may be seated. And would you state your full name, please?
Kimberly Sharon Baker Bailey.
Kimberly.
Sharon Baker Bailey.
Thank you, ma'am. All right, Mr. Johnson, go ahead.
Hello, Mrs. Bailey. How are you today? I know you don't want to be here. You asked to be kept out of it. But the video, you took the video of me running the bus into the building. Was I already there when you showed up?
No,
I was. Yes, ma'am.
not in the bus.
The bus was there. And you got half the video. Is that true?
I'm going to object.
Is that true?
He's testifying.
Over there, I just took
No, I'm asking.
Okay, hold it, there's an objection. You have to ask questions. Just
Okay.
ask questions, sir.
Okay. Was already there running the bus through when you showed up?
No.
Okay. Did you get the whole video, ma'am? Was that the beginning, what we seen today?
No, that was the middle.
That was the middle?
Yeah, that was when I was
Yes,
most
ma'am.
interested in watching the building go to,
Yes,
because
ma'am.
I thought it was.
That's what you were most interested in,
It
correct?
was just ridiculous. So.
Yes, yes, ma'am. But that is what you were most interested in, you just said, correct?
Right.
Okay. You did not know the whole story of anything, correct? Of why I was tearing the building down?
None of it was,
Right.
it was just funny to
Correct.
see a bus tear down the building.
Correct, funny to you, I understand. Did you know that I was doing it, I was trying to remove the building?
No, it didn't look like that to me, because I saw you come up and get it from one side, and then you tried it from the front side, and then the video shows you knocking it down on the left side. But I saw all sides, the bus
Correct.
running into it,
Yes, ma'am.
so it didn't look like removable.
Yeah, okay, yes, ma'am. Do you remember when the building wasn't there? Okay, yeah. And you liked that view? It was a great view. It was all pine trees, correct? Can we say that your husband and I built that building?
Yes, we can.
Okay. Your husband, if he was here today and could testify that the building was not built into the ground, correct?
I'm going to object. I think that
Okay.
can only testify about what she knows.
Okay.
That's what
That's
she
what
just
I was asking.
That's what she just said, she doesn't know.
She doesn't know, yes, sir. So when you took the video, you know that your husband and I, you just testified that your husband and I built that building.
Yeah.
Did you ever see Mrs. Johnson at that building before the year that it took us to build the building, before that time?
I'm not sure I understand that question.
Have you ever seen Mrs. Johnson out there at that building before that?
I don't think so.
Okay. And give me just a second, please. So, did you or did you not call Mrs. Johnson at work and tell her about the video that you took and what I was doing?
I did not.
Okay. When did Mrs. Johnson get the video from you?
I believe it was after the police officer shot.
After the police officer?
Well, when the police officer came, she asked me for it, and then I wasn't awake, so I sent it to her. I think it was the next morning.
Okay, how did Mrs. Johnson know that you had video of it?
I talked to her on the way through, coming from the store that evening.
Okay. So you did already tell her?
Yeah, she knew.
Before the law came?
She knew that was a video.
Okay, all right. And you never offered it to her, she never asked to see it?
Not at that time.
Nothing? I mean, just, okay, he knocked over my building, I don't want to see it. I'm glad you got a video, have a nice day. Is that the way she kind of acted to you?
No, it was more, she didn't, we were both busy.
Oh, okay.
It was like passing.
Wasn't too busy to take the video though, were we?
I was home by myself at the time watching this incredible event.
Yes, ma'am. I kind of understand. Was that me on that bus?
Yes.
Without a shadow of a doubt, you can prove that was me on that bus. You got my picture that you seen me drive that bus.
Roger, I saw you driving the bus. I also saw you get out of the bus and go look when you got it stuck and jockey it back and forth 5, 6, 7 10 times to get it out of there. Do I have that on video? No, but I saw you.
Okay, well, you might have seen it. There's tons of people that look like me. But I just want to know, is it on video that shows that was me sitting in a school bus backing into a building? Can you see my picture distinct that is me driving a school bus?
I have scoured at that place. I have other pictures and some video, but I know it was you because I saw you go by.
Okay.
You're asking if
I mean, fair enough, but can you prove that was me? That's what I'm asking. To send the video to somebody and say, he did this. Can you prove that?
Yeah, I saw you.
But.
That's
Sir,
proof that I did
that's
this.
enough, it's not an objection, but I'm going to object myself.
Okay.
You're argumentative. Move
Okay.
on. Do you have other questions? Ask other questions.
No, I rest, Your Honor.
And redirect.
Well, I was his witness, but.
Yes.
No, I have no.
Cross.
Yeah, I have no questions, Your Honor.
Okay.
You may sit down, man.
Thank you.
Or your next witness, sir.
That was my only witness, sir.
All right. Do you wish to testify yourself?
Yes, sir.
Okay. You don't have to. Let me make sure you understand this. Under the Fifth Amendment, you have a right to remain silent. You have a right against self-incrimination. So if you take the witness stand, you're waiving that. You have a
right.
You're going to get cross-examined and you get questioned about what you did, and you have to answer the questions.
Yes, sir.
You understand that?
I do, but am I allowed to show the pictures, the evidence that I have without testifying?
No.
So I must testify?
Okay.
Yes, sir.
Come up and be sworn in.
Okay. Do I bring his stuff with me, or?
Whatever you want to be admitted into evidence, you need to bring with you. Okay, let me swear you in. Raise your right hand. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth so help you God?
I do, Your Honor.
You may be seated. State your name, please.
Roger Dale Johnson, Jr.
And Mr. Johnson, we had this discussion, but on the record, you understand that by taking the stand, you're going to be subject to cross-examination. You're, in effect, waiving your Fifth Amendment right against remain silent.
I do, Your Honor.
Okay. Tell me what you want me to know about this case and the evidence that you want the court to consider.
Yes, Your Honor. Sir, that building belonged to myself and only myself. That was my personal belongings. And as you see in the divorce decree, my personal belongings were granted to me.
You have a seat, sir. You don't need to stand. We're not in England. You don't have to stand in the dock. You can sit.
By May 1, every time I went and tried to get my stuff, there was a problem. She called the law on me for this. She threw my clothes, like I said earlier, she threw my clothes out. She actually destroyed the building way before May 1. And I do have pictures to prove all this. The building that she just testified she wanted to keep and put stuff in. I do have proof, evidence, and then she wants the rubbish gone. She hired a tractor to come, which I have proof, and put it on Facebook that where she tore it apart more to spite me. So there is, I believe it's her responsibility. I never got nothing out of it. I tried, but I did have to tear it down for public safety because of the tanks where she busted the tops off the tanks. After I tried to remove it, the building was built between two pine trees that, hence the reason that I built the building. I have pictures to show you everything. Trying to remove the building between the trees without destroying her trees.
Okay, what pictures do you want the court to take into evidence?
There's probably 100 of them, sir.
Well,
If
bring them out. and
prosecution
we'll-
likes to see them first.
Yeah, they have a right to see them.
Okay. This,
No, don't tell them, just hand him the pictures,
Okay.
let them go through them and look at them.
okay. No, here. And put this, let's just do it like this. Please. Oh, no, I have one here, sir.
There's some more.
Okay, so we're going to refer to that as Defendant's Exhibit 2. It's going to be a joint exhibit of all photographs that you want the court to consider. Now, if there's particular photographs in there that you want me to pay particular attention to, you need to pull them out and tell me what is special about that particular photograph that you want to direct my attention to.
Yes, sir.
Well, let's do them one at a time. You got a particular photograph, I want you to look at this and tell me why you want me to look at
I
it.
want you to look at this, sir, and see the door on this building when the building was in good shape.
Okay, so no, give it to, let Mr. Keel go. Okay, next photograph that you want me to point something
I'm
out.
trying to get to it, sir. It's exactly the same picture.
Okay, what is this
Just a
picture?
little different angle, exact same picture, sir.
I don't need to see an exact same picture, so. You got something different, I'll look at it, but I don't need to look at multiple pictures of the same thing.
Next picture, this is, as you see, my place where I lived for the last few weeks before our divorce.
Okay, that's not relevant to this, to any of the issues I have to decide.
Okay. This is where Mrs. Johnson busted the window out of the door and knocked the tanks over. As you can see, the tanks.
And you were saying this happened before this incident?
Before the knocking of the building, yes, sir.
Okay.
And here's a little better one. A different angle. It shows more of the tanks.
Okay.
For the public safety argument, that was the reason. There's where she threw the refrigerator out when it was still attached. in the building.
And you're claiming this is before or after?
This
the
is
incident?
before. I do have pictures of the building, yes, sir.
Okay.
Intact, yes, sir. Here, give me that one so you can see, please. This is, the building's still intact.
Okay. It just has a refrigerator laying outside.
There's a better one where she destroyed the inside.
Okay.
As well here, different, a little different view. Judge, can I send you up about these 8 pictures of the same, of the destruction of the inside? Now, this one, Judge, is, I gotta find another one that shows, I do have it, shows her name of her Facebook post, where she bragged about tearing it up, and this was after the building was down, and she had the tractor to clean up and pull the door out. This is the pictures of them, but I do have more to show you to back up my proof, sir. This is not the ones I want to talk about. Here we are, sir. And if you pay attention to the top of the picture.
I see it.
Okay, thank you, sir. Yes, that's
Okay. All right, so any objection to Defendant's Exhibit 2?
And that's all of these together?
All of them.
Yeah, and we object because there's been no real foundation for them or what they represent. So
I'm going to let them in. They're admitted. Anything else, sir?
Not to, yes, sir. There is. Online, I admitted to you, no, I haven't heard it, on the original divorce decree, which it did say on that one as well, also says by May 1. By May 1. May 1 is still included. I was not violating any law as time-wise, and there was no, they still haven't proven no personal harm because of the object of what happened. Every time I tried, this is what happened. She threw the refrigerator out, or bust the glass on my doors. I never could retrieve my properties.
Okay. Any other testimony you want to give me?
I don't believe so, sir.
All right. Mr. Hill, cross-examine.
Thank you, Your Honor. Mr. Johnson, on May the 1st, was there, and looking at those pictures that you presented, there's a lot of stuff inside that building.
Yes, sir.
Are those your personal belongings in
Yes,
there?
sir.
Did you get those out before you started tearing the building
I
down?
couldn't. She destroyed it. She destroyed it. Did you not pay attention to the pictures?
Well, I mean, I saw there's furniture, there's some, looks like maybe welding stuff or something, and...
No, that's the tanks that I tried to explain to you, that she destroyed. I had to destroy it for personal safety because of the ingredients in the tanks.
To run over it with a bus?
I didn't run over it with the bus. Did you see me run over it?
All right.
You see me knock the building down.
You
sir.
did knock the building down.
So, you also did not look at all the pictures where she destroyed everything in the building. There was no personal property to retrieve, sir.
Well, we have video and pictures of the building being destroyed, and you've admitted that you destroyed the building, and how are we supposed to believe that you didn't destroy the rest of that stuff?
Because we have pictures, I have pictures of her.
That's all I have, Your Honor.
I have pictures of her with it, Your Honor.
All right. Any additional testimony you want to give to me, Mr. Johnson, as a result of the questions on cross-examination?
Yes, sir.
Go ahead.
Prosecution still hasn't proved their case against me.
That you're in the final argument now.
Well, he didn't look at all the pictures, sir.
Sir, any additional evidence you want to give me? Not argument.
Evidence? No.
Okay, you may step down.
Thank you.
Okay, so what I've got is admitted into evidence. The defendant's got two exhibits. One was the affidavit of Deputy Orsmond. Two was all the photographs. And then for the state, A, B, C, and D were admitted. Is that correct?
Yes, and the jump drive and the disc were not marked.
Yeah, those will need to be marked. They're under D. They'll be marked under D. You have any argument you want to make, Mr. Yield?
Well, Your Honor, I mean, I think it's pretty clear what happened, and I mean, there's been pretty much an admission by Mr. Johnson that he did that. He drove onto the property on the last day when his personal belongings were supposed to be removed, and instead of removing his personal belongings, he plowed the building down. The building is a fixture on the property. If he wanted the building, you take the building. You don't destroy the building. So, and we believe that it's part of the property. It certainly is not mentioned in the divorce separation agreement. So we think that he is guilty of criminal damaging, and we believe that the figure of $500 as restitution is appropriate. So we ask for him to be found guilty and with that order to be made.
Mr. Johnson, do you have any? Now you can make your argument. If you have an argument you want to make.
Yes, sir. They still haven't proved that there was criminal damaging. That property belonged to me. I tried to remove the building, as I said. The building was destroyed by her before. Well, I should have asked her to testify when she was up here. I failed to do that. But before the May 1 incident, and the video probably, if you look on the video before the school bus got there, because they only showed half the video, and my witness said she only showed the middle to us. So you never got to see the whole thing. So I feel that I'm being persecuted on something, it's not even my fault. I tried to remove the building, and then I had to destroy it for public safety, and I told you this. I also want to have it dismissed and no fees on me whatsoever because it was my property. And the property is still in my name, you know.
Anything else?
I don't believe so, sir.
All right, well, I totally disagree with just about everything that you said, sir.
Okay.
The video doesn't lie. I mean, I'm watching the video, and you don't need to respond. This doesn't call for a response.
Yes, sir.
I find you guilty of criminal damaging.
Okay.
This was gross.
Okay.
I mean, there is nothing in the divorce decree that should have made you think that you could do something like what you did.
Okay.
And if you wanted to remove the building, you should have asked for some permission from the court to do that, because it's certainly not set out in the court's order.
Okay.
So what it appeared to me was a deliberate, gross damaging of your ex-wife's property, and it appears to be out of spite and revenge to me when somebody uses a school bus like a bulldozer to destroy the property. That's what we call in the law mens rea, evil intent.
Okay.
And in our law, we punish that a lot.
Okay.
It wasn't negligence. Negligence is when you do something that's just because you're not paying attention or you don't really mean to do something evil. When you destroyed that building, you meant to do it. And I could see it from the way the bus was being driven. You don't back up and back and forth several times and knock that building down unless you meant to destroy it. And that was your intent. So I'm finding you guilty, and I'm going to give you jail time.
Okay.
I think you deserve jail time on this.
Yes, sir.
I'm sentencing you to 30 days in jail.
Okay.
And I'm ordering you, I think the restitution is light. I would have ordered a lot more. That you couldn't build that building for $500.
Okay.
But that's the only evidence they gave me, so I'm going to go with what they gave me, $500.
Yes, sir.
You're ordered to pay $500 in restitution. You'll pay that through the court, to the clerk. I'm going to order, think about what the fine should be. I think it should be $1,000. So I'm going to order $1,000 as your fine.
Yes, sir.
And the court costs.
Yes,
sir. So he's commanded into the custody of the sheriff at this time for 30 days. And I'll set him, he'll be on probation for 2 years.
Okay.
Level 4, and set a review hearing for him in about a month. So,
and I do have
time with his end of his jail sentence. So we'll make that August 31st. That'll be his first review hearing. So.
May I have the name of the who the restitution's to go to? Please?
Yeah,
Wendy Johnson.
Wendy Johnson.
Yes, sir.
Her name's on it.
This is your next review hearing.
Court's adjourned.
Thank you.
Sir, I have court on 24th.
I don't care. You're in custody.
Okay.
Get you a lawyer and deal with it that way.
Yes, sir.
Your Honor, we have 2 later items.
Okay.
State of Ohio versus Dina Cornwell, case number TRC 25-1846 A and B, CRB 25473, CRB 25444.
You're late.
I apologize, Your Honor, I worked this morning. I work in oil. I went home to shower, so I wasn't like a coal miner, and I was about 5 minutes late.
Okay, I want you to do a urine screen, because you did one last month and you were positive for alcohol. So go do a urine screen and then I'll decide what to do with you.
Okay.
State of Ohio versus William J. Spalding, case number TRD 26338 A and B, CRB 25601 A, B, C, D, and E, CRB 23512.
Okay, I do have a report from OVP that says you've had negative screens and are going to your counseling.
Yes, Your Honor. I also, Your Honor, have a copy of, I was able to obtain SR 22 insurance, so my license has been reinstated now that I've got my insurance.
You were supposed to be here on July 31st.
Yes, Your Honor, I had a,
I won't issue a warrant since you came in now, but you need to, if you're gonna come in on early.
well, I came
If
in.
your lawyer's not here today.
Yeah. I came in at 9:30 this morning and signed in, but I was,
Okay.
Josh told me I had to sign in with the clerk.
Let me give you a new date when he will be here. Because you've still got an active cases, so, let's see. The 14th, next week,
Next week, okay.
next Friday,
Next
August the
Friday.
14th. All your cases are set for them, and Mr. Steyer should hopefully be here.
Thank you, Your Honor.
You're welcome. Court's adjourned. Subject to, well, I guess I have to recall that one lady. but Court's in recess, I should say. You got a video like that.